and says, accordingly, I'm satisfied of the relevant matter. Now, clearly, the sub-conclusion, if you like, the final sentence of 24, and the description of it as a factor plainly supports the proposition that it is not intended to have been the body of 23 and 24, the expression by the Minister of a separate and independent basis for the conclusion in 25, but rather only a contributing, to use the Minister's own word, factor. That's the plain, ordinary meaning of the word factor. Now, if it were necessary, we would also note in that respect paragraph 27 of the Minister's reasons, which, and I'll come to this discussion in due course in more detail, but under the heading risk to good order, what the Minister says in the opening words of 27 is, separately and quite independently from the matters discussed above, which indicates that when the Minister wishes to express, quote, separate and independent strands of reasoning, he's done so expressly. And the fact that he hasn't done that in 23 and 24, but has instead described those matters as constituting a, quote, additional factor, means that even if 23 and 24 don't themselves embody legal error, assuming therefore there's no vice with the reasoning expressed therein, it cannot mean that the errors that we've emphasised concerning what is said in the preceding paragraphs is immaterial. Now, I won't trouble the court with it because I think it's really quite trite, but there is a useful full court decision illustrating this very same argument that I'm making in a materially similar context in a case called ARG 15. Let me find the citation. It is decision of the full court. Citation is 2016 250 Federal Court Reports 109. The relevant paragraphs, Your Honour, are 73 through to 76, where the full court endorsed the observations of Justice McCarricker in a case called SZOOR, that in assessing the connection between multiple matters that are said to lead to a conclusion, the way in which the tribunal in that case, quote, framed its reasons is significant in assessing whether a particular finding is material to the tribunal's ultimate conclusion. And I appeared to the Minister in that case and was unsuccessful in arguing that there was immateriality because there was some separate strand of the Minister's reasons that was not shown to be affected by error, and therefore the challenge was to fail. The court rejected that argument based on the way in which the reasons were framed by the tribunal in that case, which are materially the same to the way, or at least analogous. Indeed, this case is even stronger in terms of evincing the fact that the matter set out 23 and 24 are not intended to have been expressed as separate and independent bases for the conclusion that is made by the Minister at 25. 26 doesn't matter, Your Honours. 26, the Minister refers to an event that Mr Djokovic was involved in organising, being an event called the Adria Tour, or I'm not sure how that's pronounced, a charity tennis exhibition in Serbia and Croatia in June 2020. Ultimately, the Minister, albeit referring to that event, gives no weight to it because, as the Minister says, it's, quote, not clear that any of the alleged failures to comply with social distancing protocols and so forth were endorsed or encouraged by Mr Djokovic personally. So that paragraph 26 is plainly immaterial to the reasoning and can be ignored. So pausing here before we move on to good order, we've looked at the part of the Minister's reasons concerned with whether Mr Djokovic's presence in Australia may be a risk to the health of the Australian community. It's founded critically on the two, albeit decontextualised and somewhat misleadingly cited statements attributed to Mr Djokovic in April 2020 concerning his then views, and no evidence whatsoever is provided or identified, despite the fact that if such evidence existed, it could have been identified, for the proposition that mere presence of Mr Djokovic at a tournament or in a country is apt to generate anti-vax sentiment. And indeed, the only evidence identified by the Minister, being the BBC article, suggests that the anti-vax sentiment is apt to be, and indeed was, some days ago, triggered by the opposite decision that the Minister made. That is, anti-vax sentiment is triggered by the coercive state action of cancellation, not by simply letting Mr. Djokovic play some tennis. Now, can I move to the second limb of the Minister's reasoning, which is described as risk to good order. Now, notwithstanding the opening words of paragraph 27, where, as I indicated earlier, the Minister says separately and quite independently from the health risks referred to above, a material component or the same thread of reasoning that runs through the Minister's reasoning on health also materially runs through the Minister's reasoning on good order. How do I say that? We can ignore paragraphs 28 and 29 that simply refer to case law. We can ignore 30, which is uncontroversial, about the Governor-General having declared COVID-19 as a relevant list of human disease. 31 is uncontroversial about the threat that COVID-19 poses. 32 is uncontroversial about the need in a broad sense for governmental action in response to the crisis that COVID-19 presents. Now, if we move to 33, the head concept is the Minister says that behaviour by influential persons and role models which demonstrates a failure to comply with or a disregard of public health measures has the potential to undermine the efficacy of the Australian or the collectively governmental response to the evolving COVID-19 pandemic. Then goes on to say, clearly, correctly, that Mr. Djokovic is a person of influence and status, and then says, having regard to the matters set out above, and that in context picks up the discussion in the health section, regarding Mr. Djokovic's conduct after receiving a COVID-19 result, his publicly stated views, so that therefore is a reference to paragraph 18 and the decontextualised, somewhat misquoted past statements from April 2020 set out in the BBC report, as well as his unvaccinated status, I consider that his ongoing presence in Australia may pose a risk to the good order of the Australian community. So pausing there for a moment, in that sentence, an at least material element of that which the Minister says gives rise to a potential risk to good order includes his publicly stated views, which of course is the subject of paragraph 18. And the Minister goes on to say his presence in Australia may encourage other persons to disregard or act inconsistently with public health advice and policies in Australia, and then gives the only example of that being becoming vaccinated. Now, in 34, the Minister says, in addition, so notwithstanding it's said to be in addition, it really coheres with at least one material part of the subject of 33, which is the very words that the Minister uses in the final part of 33, in other words, the risk of people not becoming vaccinated. So the Minister says, in addition, Mr. Djokovic's presence may lead to an increase in anti-vax sentiment generated in the Australian community, which may lead in turn to civil unrest with rallies and protests and the like, which in turn might themselves be a source of community transmission, and then linked this, multi-sequenced series of hypotheticals to the concept discussed by Justice Goldberg in the case of Tien, which is quite something in the nature of unsettling public actions or activities, which was a description that Justice Goldberg gave back in the day of how one might understand an aspect of the meaning of the expression public order. I'm sorry, good order. Now, 35 and 36, again, all link with 34, because 35 says risk of adverse reaction by some members of the community to Mr. Djokovic's presence in Australia. So we've got the, if you like, 34 directed to the possibility of, if you like, anti-vax lobbying. 35 pro-vax. 36, the Minister says these opposing reactions may themselves be a source of discord and create public disruption. So we've got the idea, if you like, here of competing tribes, in effect, or at least metaphorically, on the streets. That gives rise to public, to concern about good order. So we can see, therefore, albeit expressed as a separate and independent head, in order to meet the requirement of section 133C3A, the Minister's reasoning, nevertheless, particularly flowing from 33 and 34, picks up the minister's reasoning set out in the health discussion, which in turn is materially driven by the statements made by Mr Djokovic, or at least that aspect thereof that the minister identifies in paragraph 18. Now, in any event, and this will be of importance in a moment in the way that I articulate ground one, in any event, we then move to the separate second mental state that the minister is required to have in order to be empowered to cancel Mr Djokovic's visa under 133C, and that is to satisfy that cancellation is in the public interest. And even if Mr Lloyd were to seek to persuade Your Honours that somehow the defects that we've identified with the minister's reasoning under the health section don't materially infect the reasoning in the good order section, the fact remains that manifestly a material element of the minister's reasoning on the public interest question concerns this very same idea, which is a focus of reasoning in the health section, which is the presence of Mr Djokovic, based at least in part on the April 2020 statements, fostering anti-vax sentiment. So I look here particularly at paragraph 39. So the second sentence in particular, so linking to what he'd said at 17, the minister says, despite my acceptance above that Mr Djokovic's recent infection with COVID-19 means he is at negligible risk of infection and therefore presents a negligible risk to those around him, I am concerned that his presence in Australia, given his, quote, well-known stance, and I'll come back to that proposition in a moment, which we say contradicts the minister's statement at 19 and wasn't open, concerned that his presence in Australia, given his, quote, well-known stance on vaccination, creates a risk of strengthening the anti-vax sentiment of a minority of the Australian community. And we say that, again, clearly, even if we haven't persuaded Your Honours that there's error in the good order section, although we pressed the submissions we've made about that, we have here articulated in 39 as a plainly material element of the minister's discussion of the public interest question, the expression of this idea, presence in Australia, because of his supposedly well-known stance, creates the risk of strengthening the anti-vax sentiment presented as a material element of the minister's reasoning, excuse me, on the public interest question. Now, further, if it may be mentioned, paragraph 43, in a belts and braces kind of way, the minister says further, still within the public interest discussion, further, the health and good order points discussed above, in other words, in the discrete sections set out above concerning health and good order, respectively, are each separately relevant to whether it's in the public interest. The health and good order of the Australian community are matters of public interest. So in other words, yet again, we find the link, if it be necessary, despite what I've already said, to defect in the analysis alone in the health section of the reasons finds its way through the doorway of paragraph 43 to materially infecting the minister's assessment of the public interest, because he has assessed that as being relevant to the public interest, which is, of course, unsurprising. Then we get to the discretion part of the minister's reasons. That's headed part C, other considerations, and a number of matters are set out therein. I think we've been corrected by Mr Lloyd. We said in writing that every one of these considerations that the minister addresses here were either held by the minister as being in favour of my client, in other words, against cancellation, or were neutral. We accept his correction that one of them was held against Mr Djokovic, although only slightly, which was the business about the Australian Travel Declaration, where the minister, albeit assuming that the failure of the Australian Travel Declaration to mention the fact that Mr Djokovic had travelled to Serbia within the 14-day period prior to arriving in Australia, the fact that that hadn't been referred to, the minister assumes that that was attributable to Mr Djokovic's agent who completed that declaration on Mr. Djokovic's behalf, and about which she drafted a stacked deck, the correctness of which has never been called into issue, saying that it was her mistake. Notwithstanding that, the Minister does say in the third last sentence, the circumstances are at most neutral, although I'm, quote, minded to give it some small weight in favour of cancellation. So we accept that correction. So the only single item in the domain of the Minister's consideration of discretion, only one went against Mr. Djokovic in a very small way. Every other one went in his favour. That matters potentially to resisting Mr. Lloyd's argument about materiality of the errors to which we that we allege. Can I turn now to deal more directly, but aided by the discussion that I've just engaged in about the Minister's reasons? Ground one, the essential point here on this is this. The Minister identifies, at least in the prism of his discussion of the public interest, but echoed really, in truth, throughout the reasons, a central material concern. That concern is the avoidance of, or the minimisation of, that which might, quote, foster anti-vax sentiment. Point two, the Minister was considering whether to cancel the visa. Therefore, before the Minister made his decision, at the point he was considering it, what he did, he had two binary choices, cancel or not cancel. If he did not cancel, then Mr. Djokovic stays in Australia, is therefore present to pick up the concept of 1161E Roman 1, and presumably stays in Australia for about 2 weeks, hoping that he wins some games, and then goes home. The binary option 2 was that which the Minister chose, cancel, and subject to the possibility of that being disturbed by this present judicial review action, that led inevitably to mandatory immigration detention for the purpose of expulsion from Australia. And indeed, as we've emphasised and has become public knowledge, a 3-year preclusionary period of Mr. Djokovic coming back to Australia unless a evaluative waiver, in effect, is exercised in his favour by the Minister in the future. Now, the only evidence, and I'm at some risk of repetition here, but I'm trying to articulate ground one and its logical structure, given the singular or central or material concern, avoiding or minimising anti-vax sentiment, given that process of consideration that the Minister was engaging in led to those two binary outcomes, it was irrational, Your Honours, for the Minister to only contemplate the prospect of the fostering of anti-vax sentiment that might accrue from Mr. Djokovic playing tennis, in other words, being present, and yet not consider the binary alternative, which was the prospect of anti-vax sentiment being fostered consequent to or following from coercive state action, being cancellation and expulsion. This is not a Pico Wall's End argument that somehow the Act on its proper construction required some freestanding matter, the Minister to consider counterfactuals or anything of that kind. It reflects no more than an appreciation that plainly Parliament is to be understood as having expected and required that the Minister, when forming requisite states of mind, including most obviously an assessment of the public interest, but also in exercising discretions, is to reason, act rationally and reasonably, which therefore involves, in a relevant respect, consistently. And so it's the product of the binary scenarios and the singular concern that generates the difficulty. Now, what makes our ground in this respect, if I can say so, even stronger, is the evidence base. And again, at risk of repetition, this court only needs to decide the case before it. And the case before it was one where there was only one single item of evidence not acknowledged by the minister in any relevant part of the reasons, but nevertheless only one item of evidence before the minister that actually bore on this question. And that item of evidence was the BBC report that only suggested anti-vax sentiment aggravated by the cancellation option. No evidence at all about anti-vax sentiment being fostered by the option that the minister did not pursue, which is simply letting my client play tennis for 2 weeks. Notwithstanding, as I've mentioned on a couple of occasions, that if such evidence existed, it could have been obtained because Mr Djokovic has been playing a lot of tennis public way throughout the period in which COVID-19 vaccinations have been developed and uptaken across the world. Now, we don't need to demonstrate that if the minister had considered the prospect of cancellation decision leading to the fostering of anti-vax sentiment, that somehow that anti-vax sentiment would have been greater than that which the minister contemplated as conceivable flowing from the mere presence of Mr Djokovic in Australia. Although, again, I hasten to add, it was the only evidence that existed on the subject. We only need to demonstrate that if the minister had considered this prospect of the binary scenario, what if I cancel? Might that lead to anti-vax sentiment? We only need to demonstrate that there was a material possibility of the minister being satisfied that there was a prospect of some such anti-vax sentiment. Why is that? Because ultimately this was a balancing of scales exercise. And as I've mentioned earlier, all but one of the discretionary factors went in Mr Djokovic's favour. If therefore there was a counterweight on the scales, particularly through the prism of the public interest question, such that even if the minister was not errant, as we say he was, in finding that there was a basis for saying that there may be a risk that Mr Djokovic's mere presence would aggravate anti-vaxxers. So even if that wasn't wrong for the minister to say that, if there was plainly an appreciation by the minister, an assessment of this, at least through the public interest lens or discretion, of a prospect of material amount of anti-vax sentiment being fostered by the opposite decision, the one that he made, cancellation, then plainly there's a material prospect in the sense of a realistic possibility that even if the subjective jurisdictional fact in 133CA was met, that the public interest assessment in B might have differed because of the balancing of the scales, or the discretionary exercise might have differed, again, because of the balancing of the scales. But in any event, all of that defence is unnecessary because, as I repeat, the only evidence whatsoever was suggestive of aggravation of anti-vax sentiment as a consequence of cancellation. Now, I think that if we haven't been as clear as we could have been in obviously the fairly limited time we had to both digest the minister's reasons, articulate an application and prepare submissions in the 36 or so hours since we were given this material by the minister on Friday evening, I think the clearest and most attractive window through which to view the error is the public interest lens. In other words, I can accept it might be argued that it might be open to the minister, subject to our grounds 2 and 3, which I'll come to in a minute. Let's assume, in other words, it was open to the minister without any evidence to find that there was, because of the lowness of the bar in 1161A1, that there may, that the mere presence of Mr Djokovic in Australia may generate a risk of anti-vax sentiment. Let's assume there's no problem with that, although we don't agree. And let's assume that even if the minister had considered the binary alternative, which is anti-vax sentiment being fostered by cancellation, and let's assume for the sake of argument that because of the way that 133CA is structured, well, it might be said by Mr Lloyd, well, who cares? If the minister could say, well, I'm satisfied that its presence here would foster anti-vax sentiment, it's not necessary for me to think about the binary alternative because the mere presence and the fact that my cancellation might also foster the anti-vax sentiment is immaterial. And we don't accept that, but I can see that that's arguable. Now, what we say is a very strong argument is that when the minister then approaches the lens of the public interest, The minister can't, given the singular concern that he identified, particularly at paragraph 39 of the reasons, and the binary outcomes of however he decided following the consideration of the possible exercise of the power, it is irrational or unreasonable to look at only one side of the coin, particularly whereas here, as we've belaboured the point, the only evidence that did exist concerned the risks consequent to cancellation, demonstrated by the fact that there has already been a cancellation decision, albeit that it was successfully challenged on judicial review. There is no, respectfully, Your Honours, good answer to that submission. And my friend's arguments, which focus on 133CA, therefore, in that respect, miss the best point. Now, the same could be said about the discretion to the extent that's necessary. Now, were I forced to argue the point about 133CA, although I don't think I am, or we are, we would say this, that it is somewhat perverse to adopt such a narrow focal point or lens on the 133CA question and to blinker oneself to only thinking about risks consequent to presence when there is before you evidence bearing on risks of what is the binary alternative, which is non-presence following from cancellation. And so we would argue, if necessary, which I don't think it is, that the error can be seen as being located through 133CA as well. In other words, the unreasonableness or irrationality can be located in A. But I accept it's the harder argument, but I say it doesn't matter because plainly it comes up through public interest that the device was looking at only one side of the coin. Plainly it comes up in discretion device in looking at only one side of the coin. Now, what I want to do now, Your Honours, is to, as quickly as I can, deal with the Minister's answer to this ground. And I should try to reassure the court that I'm spending a fair bit of time on the Minister's reasons. I'm spending a fair bit of time on ground 1. I will be much briefer on grounds 2 and 3. Now, the Minister's principal answer to ground 1 is the point that I've already dealt with, which is the assertion that somehow M64 and the quote where they omit the relevant qualifying sentence somehow stands against the proposition that the document ascribed by the Minister of Statement of Reasons is somehow the suggestion is that it's not to be understood as that at all, or that we haven't discharged notice of proof. I don't need to say anything else about that. Plainly, given the way that the document has been styled, given its comprehensive character, we can infer, the court can infer, that matters not mentioned are not considered or were not considered. Now, what I want to do now is, having made that point, then deal with a series of references that the Minister makes to paragraphs of the Minister's reasons, which are erected by the Minister as some kind of proof that what the Minister describes in his submissions as the counter argument was considered by the Minister. None of them are persuasive. Let me work through them. So to assist the court in noting that the time pressure that the court is under to in this extraordinary case, I'll give you on his references. So paragraph 49 of the Minister's submissions, the Minister suggests that somehow paragraph 7 of the Minister's reasons evince consideration. It doesn't. So paragraph 7 simply says, in the Minister's reasons, says, in case there might have been anything else that Mr Djokovic wanted to say that is not said, I've done my best to consider matters alive to the fact that Mr Djokovic's view may not have been sought on everything. But it really doesn't assist. What has been said in the preceding paragraphs is that the Minister's recorded that Mr Djokovic and those who advise him did make a series of arguments to the Minister following the hearing in the Federal Circuit Family Court on Monday. As it transpired, nearly all of that missed its target because the Minister took a radically different approach to the present decision-making process. But one can't draw anything out of 7 to evince active intellectual consideration of the matter that we say on the Minister's own criteria and on his own reasoning in order for the Minister to be acting reasonably, rationally and consistently needed to be considered, which is the prospective anti-vax sentiment being fostered by a cancellation decision. The Minister's subs at paragraph 50 then invite the court to say that paragraph 22 of the Minister's reasons support his the inference that somehow the minister did consider the counter argument, but it doesn't. I take it that the minister is referring here to the reference in Roman 2 to the media report that some groups opposed to vaccination have supported Mr Djokovic's presence in Australia. But as I've already mentioned, it's pretty problematic the minister relying on that statement, given that the attachments A and L the minister refers to don't say that at all. In any event, the point was that so far as there is reference there by the minister to anti-vax groups, although plainly erroneously, it's focused on the wrong side of the coin. It's focused on the suggestion of support for presence. It says nothing about that which was in the BBC article, which is attachment H, which was the aggravation of anti-vax sentiment that was triggered by the first purported cancellation decision, being the side of the coin that's the point that the minister didn't consider. Can I say at this point, and perhaps I've been remiss in not doing this already, but I think it's an important submission to frame this whole discussion. Have Your Honours received a copy provided separately this morning by my instructors in a case called CWY 20? So it's Acting Minister for Immigration, and CWY 20 citation is 2021 FCA FC 195. A judgment of 5 members of this court, including relevantly Your Honour the Chief Justice and Justice Pasanko. Now, Your Honour Justice Pasanko gave the lead judgment with which other members of the court agreed. And the relevant paragraph that I wanted to draw this court's attention to is paragraph 130, located within the reasons of Justice Pasanko, and I'll read it out. It says, the cases are legion in which the courts have said that it's not appropriate or ordinarily appropriate to infer that the decision maker has made findings or drawn conclusions not referred to in the written reasons of the decision maker. That frames this whole discussion. Notwithstanding, if you like, that the BBC article was before the minister, and plainly, as I've said a number of times, provided the only evidence provided support for the prospect of anti-vax sentiment being fostered by cancellation, not the other way around. One can't say, oh, well, somehow we're just to infer or guess by snippets of this and that in the minister's reasons that somehow were to infer that that was actively considered. That flies in the face of the significance of statements of reasons, notwithstanding produced here voluntarily, done so as a purportedly comprehensive document. And therefore one can't readily be reading in active consideration that one doesn't see. So if I come back to the minister's references, paragraph 50 also refers to paragraph 36 of the minister's reasons as somehow supporting his position. If I could take Your Honours to that. Paragraph 36 doesn't provide any support for his assertion that the minister did actively and intellectually consider this matter, because 36 was concerned with what's called the opposing reactions. So this was the idea that I addressed earlier, that there might be different tribes on the streets of Melbourne having conflict about Mr Djokovic and his stance or the like. But that was all directed at the possibility of Mr Djokovic's presence in Australia. That's the whole discussion that the minister's engaging with here. So there's no consideration whatsoever to anti-vax sentiment being encouraged or aggravated by the cancellation decision. The minister subs at 52 then asked the court to look at paragraph 46 of the minister's reasons. That similarly doesn't help him. 46 of the minister's reasons says, I acknowledge that Mr Djokovic is now in the community. So this was the interval of time after we succeeded after the first case, but before the minister's current decision, after which Mr Djokovic was re-detained. It says, I acknowledge that Mr Djokovic is now in the community and some unrest has already occurred such that it's too late to avoid it. So what the minister's really doing here is saying, well, while Mr Djokovic has been present for that fraction of time, those few days, there's nothing I can do about avoiding that now, but I'm making a decision, so we're getting on with it. But again, the whole frame of reference is to, in this part dealing with good order, is to if Mr Djokovic is present in Australia. That's what the minister did purport to consider, although without any evidence. But again, it provides no support for Mr Lloyd's submission that the minister did actively consider the prospect of anti-vax sentiment being aggravated by a cancellation decision. Again, the matter about which, to the extent there was evidence, that was where the evidence went. The minister at paragraph 53 of his submissions then asks the court to look at paragraphs 44 and 45 of the minister's reasons. That goes nowhere. Paragraph 44 simply summarises submissions that Mr Djokovic and those who advised him made in a period of time after the first court action, which, as I said, ultimately went nowhere because the minister radically reframed his approach. I cannot see how anything in 44 that summarises those submissions or anything in 45 that responds to those submissions can possibly be seen as supporting a finding or an inference that the minister actively or intellectually considered that which we say he would have had to have done in order to act rationally and reasonably. The minister at 54 of his subs refers to paragraph 67 of the minister's reasons. This again is extremely weak. At 67 of the minister's reasons, the minister only refers to awareness that the Serbian government has expressed strong support for Mr Djokovic to remain in Australia and that the Serbian government may react negatively to the cancellation of the visa. That says absolutely nothing whatsoever about what is the subject of our ground, which is the aggravation of anti-vaxxers, that being the singular concern of the minister identified himself. So that's it. There are no more paragraphs that I've picked up that the minister sought to persuade the court that this was considered, let alone actively intellectually, notwithstanding in any event there was no evidence. In terms of the material before the minister, again, this is sort of beyond that which is necessary because one shouldn't really be going beyond the minister's own published reasons to try to find evidence of what he considered. That's orthodox principle, but nevertheless the minister invites the court to do so, so I will briefly respond. The minister invites the court now to look at the department's submission to the minister. So the minister invites the court to look at, bear with me. So paragraph 55 of the minister's submissions to this court says there was a departmental submission to the minister that stated that Mr Djokovic's presence in Australia may create a risk of strengthening anti-vax sentiment. And there were materials supporting this. Well, again, that deals with one side of the coin. It doesn't deal with the side of the coin that our argument is directed to. 56 to 58 of the minister's submissions also go nowhere. So at 56, the department cited part of the if you like, the case that was presented by Mr Djokovic's advisors in the period of days after the first court case was that one such item in the submission was a reference to the fact that there'd been a, quote, online poll in The Age that showed support for Mr Djokovic remaining in Australia at 60%, and there was a screenshot, and there was reference made by Mr Djokovic's advisors to the fact that there was an online petition for Mr Djokovic to be free to play in Australia, for which there was 83,000 signatures, and another reference to an online poll at 57. None of that, aside from the fact that it wasn't discussed by the minister in any meaningful way, so this is all just reconstruction of reasons anyway, to the extent that that's what the minister's going to this stuff for, none of that has any probative significance to the point about galvanising, anti-vax sentiment being triggered or galvanised by a cancellation decision. The fact that a certain proportion of people in a certain poll preferred Mr Djokovic to stay say anything about galvanising anti-vax sentiment if he's cancelled. So that goes nowhere. Paragraph 59 of the minister's submissions to this court refers to particular statements, particular parts of the BBC article, indeed the very part of the BBC article that I've focused on, which is the only evidence that did exist on the relationship between anti-vax groups and Djokovic, and that was the anti-vax groups responding adversely to the first cancellation decision. But yet that's our point. The minister now in his submissions is saying there was evidence of the very point that we're speaking about, but that underlines the error, Your Honours, because this is the only evidence that there was, and yet this evidence isn't discussed, deliberated on, or considered by the minister in any part of his reasons. So, in summary, Your Honours, if the minister, insofar as the minister's answer to this ground is that One's to glean from the references that I've mentioned that the minister did actively and intellectually consider the issue. The minister's grasping at straws. There's just no foundation for that conclusion whatsoever. It was not considered. I think I've already addressed the way that we push how jurisdictional error flows from that. The easiest way is to view it through the prism of public interest, that it can equally be done in the discretion. And although I accept that insofar as the prism might be 133CA, that is the state of satisfaction about risk itself, that's a harder argument. It can be put that way too, but I don't really need to go there. That leaves the only question being materiality. The minister's submissions in this respect are brief. The minister says at paragraph 78 of his submissions, aptly in my respectful submission, that it might seem striking to suggest that not considering an argument could fail materiality when that argument goes to matters as broad as the public interest and the discretion. Well, indeed. The minister goes on to say it's not unusual, cites a case that's materially different to the present one. Our written reply deals with it. The short point, Your Honour, is that there is no way that in this domain, which concerned ultimately both in the public interest prism and the discretion, an evaluative weighing exercise, in circumstances where, as I've said, the vast bulk of matters discussed by the minister was said to go in Mr Djokovic's favour, where the minister's ultimate conclusion at paragraph 69 of his reasons was expressed as only being that the health and good order considerations outweighed simpliciter, the many matters that went in Mr Djokovic's favour. It cannot seriously be put that if we're right in saying that the minister erred in legal principle, be it irrationality or unreasonableness or the like, in not thinking about the other side of the coin, it cannot seriously be said that in those circumstances, an evaluative matter, many things going in my client's favour, acknowledged by the minister as such, and where the simple conclusion was one of nearly outweighed, not strongly outweighed, not vastly outweighed, that the decision might, realistically, to pick up the High Court's language in the recent case law on materiality, have made a difference. It plainly could have. That's ground one. I can be much briefer on ground 2 and ground 3, Your Honours. I expect I'm probably about 15 minutes from finishing, if that gives the court assurance. A couple of points on ground 2. First, as I think is uncontroversial, the minister was required, to be clear, ground 2 is directed to attacking the minister's purported state of satisfaction in 133C3A. So satisfied that Mr Djokovic's presence in Australia may cause either or both of the relevant risks to health or good order. Now, the first legal point I think is uncontroversial. The minister was required to be positively satisfied. This is not like a visa application case where the visa applicant needs to satisfy the minister. It was the minister who needed to be positively satisfied in order for the power potentially to be enlightened. Point 2, which again I expect ought to be trite, and drawing from what Justice Derrington said in the case of EHF 17 that we've referred to in writing, is that to be lawful, such a state of satisfaction must be formed, quote, rationally upon findings of fact which are logically founded, sorry, I can't read my own notes, by probative evidence. Now, as I've said, the only evidence, the only evidence here was the BBC report that concerned anti-vax sentiment following cancellation. As I've said, if there were evidence about anti-vax sentiment consequent to Mr Djokovic merely being in a place and playing tennis, then such evidence could have been obtained if it existed, because this has been happening for a long time, playing tennis. but no such evidence was identified. So we therefore, and moreover, and this is the simple point, but its simplicity doesn't belie its importance, is that the only finding by the minister in his reasons at 22 Roman 2 in the parentheses is manifestly erroneous, because those media reports say nothing of the sort that the minister says they say. Don't refer to Mr. Djokovic at all. So we've got elementary error here, Your Honours. I think I've made most of the points in my notes already in the course of argument. Can I take Your Honours on this ground? Can I take Your Honours, however, to a useful part of the minister's submissions? If we go to paragraph 88 of the minister's submissions, after discussing some case law about the height of the bar or the lowness of the bar, more aptly in 1161E1, may be a risk, the minister usefully says this, that the forward-looking and low probability features of the matter of which the minister need to be satisfied are important. Facts about future conduct are not the same as facts about the past or the present and cannot be proved in precisely the same ways or to the same degree of confidence. We agree. Proof of future possibilities is very similar to proof of past hypothetical situations, which is made clear by the High Court's discussion of a couple of cases that they mentioned. We agree. As to the consideration of hypotheticals, and thus as to the proof of future possibilities, it's been recognised that the inquiry necessarily proceeds by drawing inferences from known facts. We agree. And based on reasonable conjecture within the parameters set by the historical facts. We agree. Where, I ask rhetorically, in the material before the minister, was the known or historical fact or occurrence that rationally founded the minister's purported state of satisfaction that the mere presence in Australia of Mr. Djokovic may be apt to generate the consequences that the minister speaks of in his reasons, including generating anti-vax sentiment. As I've said, there's been ample historical period within which, if evidence, facts existed, they could have been identified. None were. None were before the minister. None were identified. The minister's subs, Your Honours, at paragraphs 90 to 96, I won't read them all out, but let me just say globally, misstate or misunderstand our argument and don't therefore properly respond to it. The question is not, for this ground, was there evidence capable of supporting a finding about Mr. Djokovic's stance or position on vaccination? That's the subject of ground 3. I'll come to it in a moment. So set that aside for a moment. I'll come to that in ground 3. Ground 2 is connected with the proposition that there needed to be, to use the minister's concepts in paragraph 88, known facts or occurrences, something, skerrick indeed, of evidence that supplied the basis for the reasonable conjecture with which 1161E1 is concerned about presence causing anti-vax sentiment with all of the consequences for people not taking up vaccination and the like, but there was none. Can I move to ground 3?
Mr. Wood, before you do that, can you help me with a point of clarification? In paragraph 41, you referred to some observations that Justice Derrington made in EHF 17, and the point about the test of reasonableness in relation to a subjective state of satisfaction has been considered in many High Court cases, including Escher. Are you suggesting that what Justice Derrington said is the same or any different?
It is the same, and indeed EHF 17 is a case where Justice Derrington engaged in an extremely detailed discussion of matters bearing on the review of subjective jurisdictional facts. His Honour's analysis was endorsed by a full court, a case called Singh. I'm sorry I don't have the citation, albeit that His Honour was a member of the majority of that full court that endorsed it. So I don't perceive there to be, and I don't think there is, any relevant divergence between the proposition that we've cited in paragraph 41 of Justice Derrington, which was picked up and applied by Justice Banks-Smith and Leota, and the High Court jurisprudence to which Your Honour refers, which indeed Justice Derrington discusses in the HF.
Right, thank you.
Mr. Wood, there may be some necessity to recognise that the word evidence should not mislead one into thinking that what is really necessary is that there be material before a decision maker, which material includes the rational and reasonable use of perception and common sense and place of the decision maker in the position he or she is in. Now, that's been traversed by the High Court last year in Vianney to a degree, which you may assume that the court is aware of. But I think one needs to be careful about speaking about evidence in the sense of litigation. If one's in the AAT, however, that is the Administrative Appeals Tribunal or a court, one will be talking about evidence and admissible evidence and the like. Before a decision maker, it's the legitimacy of the material that's before the decision maker and whether or not it is of sufficient character, including what can be drawn from both common sense and the perception of the minister relevantly to matters in the community.
I accept that, Your Honour. Can I move to ground 3? Ground 3 is concerned with aspects of the minister's reasons that relate to my client's supposed stance on vaccination. And I start with this observation that there is a contradiction within the minister's own reasons on this topic. As I indicated earlier, in paragraph 18, the minister refers only to historic, decontextualised and not fully quoted, evidence of historic views of Mr Djokovic without the full quotes and so forth. And in paragraph 19, excuse me, the minister says, I have not sought the views of Mr Djokovic on his present attitude to vaccination. Now, not only does that imply, as I indicated earlier, that the minister contemplated doing so but decided not to for whatever reason that he didn't explain, but it also necessarily implies that the minister accepts that he therefore doesn't know what Mr Djokovic's present views are. And to put that in further context is to be recalled that the BBC report that referred to what Mr Djokovic said in April 2020 were, as indeed the report shows, statements not fully quoted by the minister attributed to Mr Djokovic before COVID-19 vaccines had even been developed, tested and uptaken throughout the world. And indeed, it is material in that respect, and it is significant that the minister does not cite what one would think would be a rather significant qualification identified in the BBC article, which is attributed to Mr. Djokovic, which was that he was no expert, he'd keep an open mind. Now, so bear in mind paragraph 19 with the implications that flow from it that I've just mentioned, and then go to paragraph 39, which is located in the discussion about the public interest. Recall that in paragraph 19, which was located in the part of the reasons that concerned health, in other words, the subjective jurisdictional fact 133C 3A, intersecting with 1161E round 1. And in that part, dealing with health, the minister said he was concerned about perceptions as well. He didn't say what those perceptions were, but he said, well, even though I don't quite know what Mr. Djokovic thinks in substance, I think the public perceives him as having certain views, even though we didn't identify what those perceived views were. But nevertheless, when we come to the public interest, what relevantly the minister says in the second sentence of 39 is, having passed over the fact that he assumes or accepts that Mr. Djokovic in fact only poses a negligible risk of infecting other people, says, I'm concerned that his presence in Australia, given his well-known stance on vaccination, creates a risk. What is that well-known stance? The minister doesn't identify it. The minister couldn't possibly identify it because, as the minister said in 19, including by implication, he didn't know what it was and he decided not to ask. Now, setting aside issues sometimes perhaps inaptly referred to as duties to inquire and so forth, about which we've made some submissions, there is an essential problem within, therefore, the body of the minister's own reasons in that respect. The minister in 39, and perhaps also reinforced by 42 in the public interest discussion, focuses in effect on well-known, implicitly actual, not simply perceived perhaps wrongly, stance, and yet doesn't know what it is. Irrespective of duties to inquire, it is in a more elementary sense not open to the minister to base reasoning in 39 in light of the qualifications that he himself made in 19 correctly. We otherwise rely on our written submissions, if it please the court.
Thank you, Mr. Wood. Mr. Lloyd,
that was a long one.
we perhaps might break at 12 for lunch at 12:30.
Lunch? Come on.
For say an hour or so. So depending on how long you think you'll be, if you want to take the first, we may break slightly earlier than that, but if you want to take the first 45 minutes to an hour, structuring what you want to say before we have the break, that's convenient for you.
Thank you, Anna. I'm happy to do that. I will proceed on the assumption that the court has had the opportunity to and has read our written submissions, and I
You
will
may assume on both assumptions.
Thank you, Anna, and I'll largely be speaking to them. We've tried to put as much in them to sort of save time as possible, so I'll take that approach. The applicant's grounds rely upon one of three findings they asked the court to make. First, there is that there was no evidential basis to conclude that the applicant was opposed to vaccination against COVID-19. That's at the heart of ground 3. The second is that there was no evidential basis to conclude that the applicant's presence in Australia may foster sentiment opposed to vaccination against COVID-19. That is at the heart of ground 2. And thirdly, that the minister failed to consider whether cancelling the applicant's visa would foster sentiment opposed to vaccination against COVID-19. That is his binary argument, and that's a finding which is critical to ground one. We will contend that none of those findings should be made. They involve, of course, a consideration of the reasons of the minister and the submissions and material before him. We have prepared two annexures. If the court has handy our written submissions, I can ask the court to go to that. And starting, first of all, with page 28 of the submissions, there's an annexure which extracts the material or evidence before the court that we say is relevant to the issue of of the applicant's views about COVID-19 vaccination and indeed for steps that flow from that. In relation to a question that Your Honour, the Chief Justice asked about the nature of evidence, we certainly embrace the view that it isn't limited to something like evidence before a court. Administrative decision makers typically inform themselves by a much broader range of materials. And just for the reference, for the court's records, I'll refer to a decision FUD 18 and the Minister, 2020 FCA 48 at paragraph 53. But then going back to Annexure B, Your Honours will see that it's in tabular form. Some of this material you've been taken to, but it's just convenient to go through it in this form. Relates to grounds 2 and aspects of ground 3 and aspects of ground 2. We say we acknowledge that there are inferences or that inferences are drawn from this material, but we say that the inferences that are drawn are certainly open. We also have mentioned in our submissions that the recent High Court case in Vian and the broad scope that allows for the Minister to have regard to, common sense and personal knowledge about things, and that needs to be taken into account, we say. Now, I won't go through the whole table, but I'll just go to a few points. The first item, taking the first item to show how the table works, the number on the left-hand column is the page number from the affidavit of Ms. Bannister, which the court has. So if the court's looking for this material later, that's where Your Honours will find it. And then there's a pinpoint reference for where to find it within that material. And then column 3 extracts the material that we rely upon. And I suppose the underlining draws attention to the particular bits of the extracts that we rely upon. Now, the first page deals with, in this case, material that was in the submission to the Minister, and the next 3 pages deal with material that was in the attachments to that. Now, starting at the first item, it draws attention first to the applicant being a high-profile, unvaccinated individual. And that, my friend fairly said, is not in contest. That is certainly true. It's not just for the applicant's public statements that he is opposed to vaccination. It is the fact that his ongoing non-vaccination status up to and including January 2022 at this stage of the pandemic. It's open to infer that a person in the applicant's position could have been vaccinated if he wanted to be. And we would say that this falls within the Vian kind of reasoning. That he's still unvaccinated reflects a choice on his part to remain unvaccinated even when he could be vaccinated. The material before the Minister permitted him, that is the Minister, to rationally to assume that the applicant had a temporary reason since being infected in December of 1991 with COVID for not being presently vaccinated. That is to say, the Minister's reasons are prepared to assume that because he was infected in mid-December, that's a reason why he couldn't have been vaccinated since mid-December. But of course, there's nothing to suggest that in the year or so before then, when vaccines were available, that is just his choice. That's why he isn't vaccinated, or at least the minister's entitled to assume that it was his choice. Certainly, there's never been any material presented to the minister or any claim that I'm aware of that the applicant had any other medical reason for not being vaccinated. His sole medical reason for not being vaccinated was that he was infected in mid-December, and that gives rise, at least on some views, to a need not to be vaccinated for a period of time. Now, we say that choice may support an inference as to his views against COVID-19 vaccination. The passage in the annexure goes on to refer, that's the first bit of the document, goes on to refer to a note that says he has publicly opposed becoming vaccinated against COVID-19. Now, it is a quoted passage that supported that characterization of him being opposed to vaccination. Item 3, this is what was in the submission to the minister. Item 3 in this table largely repeats that. It characterises his vaccination as being well known. That was what the department characterised it for the minister. And we say that by the time that the minister made his decision, which of course is several days after the previous decision, it was unambiguously true that it was well known what the applicant's vaccination status was, and then anyone could infer, we would say, that somebody who had by this time not been vaccinated was doing so by a choice to not be vaccinated. Turning over the page, there's then primary evidence from the attachments. In the third item, which is attachment H, to which the court has been taken already, that's from a January article of this year. There is a passage about being opposed to vaccination in the first paragraph in that section, or saying that he was opposed to vaccination. So that supports something that's in the minister's reasons. It was before vaccinations were available. He said that before vaccinations were available. Now, the applicant seems to say that diminishes the usefulness of relying upon it because vaccinations weren't even available. But we say, if anything, it strengthens it. So even before vaccinations were available, he was against them. His prima facie position is to be against them. Sure, he left open the possibility that he might change his mind, but nonetheless, his publicly stated position was that he was not in favour of taking vaccines. And so far as we're aware, that publicly stated position has not been updated. So he hasn't. So there was a statement issued, which is attachment O, last week, in which the applicant made statements pertaining to this issue. He didn't retract or offer any different view. He's not, after all this time, vaccinated. So we say that the fact that he might change his mind one day doesn't make the minister's inference about his views on vaccines not open. And of course, once it's open, it's for the minister to evaluate that material, and we say that that's what happened. Now, 2 paragraphs further down, but within the same entry, a statement could be fairly characterized as opposition to vaccination, when he says he wouldn't want to be forced by someone to take a vaccine to travel or to compete. I mean, it's certainly not supporting of vaccination, and it's not even neutral about vaccinations. It is a view which could be seen as consistent with the minister's inference. And then at the still within the same item, but immediately before the heading anti-vaccine activists, there is an expression about creating misconceptions, and that the applicant was accused of creating misconceptions. In context, that's about vaccination. So again, that is material which supports provides, we say, a firm basis to draw a view. All of that material and all of the reasoning that I've canvassed provides a firm basis by which the minister could draw the inference that he did. There's then a heading about anti-vaccine activists, which the court has been taken to in the substantive document, but here there's a reference to it having galvanized anti-vaccination activists. Now, one point that is, repeatedly put against us is this horrible, horrible error. Your Honours have handy paragraph 22 of the Minister's Statement of Reasons. My friend repeatedly says K and L, attachments K and L don't support the words in the brackets. No, but K and L don't appear within the brackets. K and L appear afterwards. K and L support the first part of the sentence, a reinforcing of views of the minority in the Australian community who remain unvaccinated against COVID-19 and who are at risk of contracting 19. That's what attachments K and L relate to. Then there's a bracketed text, as to which there are media reports that some groups opposed to vaccination have supported Mr. Djokovic's presence in Australia. And this document, the material under anti-vaccine, is clearly evidence of that. And my friend took the court to it. I mean, the mere fact that it doesn't say attachment H in 22.2 doesn't mean the minister hasn't read it or relied upon it. He refers to having relied upon it, contrary to one of my friend's other submissions that it's not referred to in paragraph 18. So the minister clearly read attachment H. He's referred to it expressly there, and the great sin is he hasn't mentioned it again inside the brackets in 22.2. It's not a basis of there being some fundamental lack of evidence. There is evidence, and my friend took it to it. And one sees at the end of that H a reference to so-called anti-vaccination groups treating the applicant as a hero or as an icon of free choice. Now, the next item is P. I won't go through all of that. That relates to a tour that the applicant was involved in running. But I just draw attention to the third bit of underlining where it says page 144. So that article says, but he was hardly a big winner during the forced off-season. He generated concern and controversy by questioning vaccination. So that's further evidence about Mr. Djokovic's view about vaccination. So I'll leave an extra B here and go to an extra A. So that's the evidence that we will ultimately rely upon when we come to our substantive submissions about that. Now, an extra A deals with a slightly different thing. This deals with the evidence that pertains to what we have called the counter-argument, but my friend refers to as the sort of the binary matter not considered. Ultimately, we say it's a matter of did the minister consider the consequences of his decision, and we say that this shows that he did consider it, and he considered it broadly, and in a way that, for reasons I'll come to when I develop the substantive submissions, is inconsistent with any suggestion that the issues weren't considered at all, which is how my friend would put it. So the first table in Annexure A is drawn from the minister's signed Statement of Reasons. The second table is from the submission to him, and the third table is from attachments to that submission. We're going to the first item on the first sort of sub-table, at paragraph 10 of the reasons. That shows, we say, the Minister was aware of some activity, community opposition to vaccination. So that's what we rely upon that for, the sort of awareness of community opposition. It's hard to imagine anyone in Australia is not aware of that, but if it be needed to be shown, the Minister is aware of it. The third item, paragraph 22, refers to media reports that vaccination opposition groups have supported the applicant's presence in Australia. And so that, I think, I've already dealt with that under 22.2, so I maybe don't need to deal with that again. The fourth item deals with paragraphs 35 and 36. In 36, it refers to opposing reactions. So that shows that the Minister is aware that there's opposing groups in relation to, inter alia, the anti-vaccine issue that pertain to Mr. Djokovic and Mr. Djokovic's presence in Australia. That was a perception of the Minister of opposing reactions. So it's not just the Minister looking at one side. He appreciates that there are segments of the community that hold strong views both for Mr. Djokovic and his views on vaccine and against them. Then the sixth item, which is paragraph 45, we say further identifies the Minister was aware of groups supporting the applicant's presence in Australia, and that they may be a source of, sorry, I withdraw that, and thus, but such groups would be opposing the cancellation, which of course is the opposite side of the decision, of the binary decision. And then paragraph 46 contains specific reference to a measure of unrest in the community that had already occurred. That unrest refers to unrest from supporting groups of the applicant, especially after the first cancellation decision. We say attachment A, in the attachment section of the report at the bottom of that page, attachment A in a letter from the applicants, or is a letter from the applicants' solicitors, and it refers to the fact that there was vocal support for the applicant to remain and play. That support could plainly materialise into discord and unrest and dissent or resentment, and Minister should be taken to have been aware of and factored that in, we would say, or to have taken it into account when he was exercising his broad public interest considerations and discretions. Then there's a reference to attachment H, which I've already taken the court to in a sense. It has a reference to the galvanising of anti-vaccination activist groups and refers, as I've said, to the Minister, to the applicant being a hero for some of those groups. Attachment L at the bottom is the Minister being aware of other activities that anti-vaccine groups do that might cause unrest and protests. Now that's all I need to do by way of evidence. I'll now move back to the body of our submissions. From paragraph 7 to paragraph 12, we briefly summarise the reasons of the Minister in concluding that the applicant's presence in Australia may be a risk to the health of the Australian community. We do it succinctly at this point, at the beginning, just to show that while the applicant might not agree with the reasons, it's not illogical or irrational. And so we say, I won't rehearse them, but they stand for themselves, and we say that they're at the very least open, if not kind of obvious. I don't understand that the applicants actually dispute the logic of that per se. Rather, they take issues with two steps in it. First, they say that it's wrong to have characterised, that it wrongly characterises the applicant as being opposed to COVID-19. And secondly, that even if he was, that one could infer that his presence in Australia would foster others to share his sentiment and behaviour about vaccines. Now, we've already addressed the evidence pertaining to that, so I'll make some further submissions on that later, but that's the structure of the reasons on that. Then in the next section, B 1.2, we address the Minister's reasoning on good order.
Mr. Lloyd, can you just help me in this regard? The terms of the provision, section 116, in section 116, is that what will occur because of the visa holder's presence, the present visa holder's presence, or continuing presence in Australia. How do you put essentially the counterfactual or counter-argument, doesn't matter how you describe it, if you could just summarise the point for me, and leave aside the evidence for the moment. One could see in a situation where it was plain to anyone with common sense that cancelling the visa would cause overwhelming public discord and risks of transmission through very large public gatherings. And one could see, in a sense, the counterfactual overwhelming the mere focus on, only on, if it be only a focus on the consequence of presence. But putting to one side, I think, for the purposes of present argument, that kind of obviously overwhelming risk of mass demonstrations of huge numbers of people. How is it that one needs to be precise or focused upon the counterfactual?
Well, I suppose, I mean, I will come to this, but the starting point we would say is that section 116(1)(e) doesn't call for a counterfactual at all. So it just asks to look for the presence of a person in Australia. And in a sense, the idea of asking for a counterfactual raises the somewhat surprising notion that Australia would, when deciding whether or not to cancel a visa, might have to avoid cancelling a visa for somebody who's, actually presenting risks when they are in Australia, in relation to sort of Australia's sovereignty in determining who gets to come to Australia is held at risk because the cancellation might lead to adverse consequences. We say that that isn't a mandatory consideration. We accept that it is relevant. We're not saying it's excluded, but we don't say it's required. And here our answer is that, in a sense, it was all obvious, and it was obviously the Minister was aware that his decision to cancel would result in some level of further unrest. But the Minister, no doubt, was principally concerned, as he says it was a primary concern, that Mr. Djokovic's presence would encourage people to emulate his position, and that would put the health of Australians at risk. And that was the concern. So on one side, maybe there is, as he accepted, some measure of unrest might flow, but on the other side, there was a concern that it would encourage people in two respects. One is the sort of the paragraph 18 to 22 respects, which is to say it would help foster Mr. Djokovic's what is characterized as an anti-vaccination sentiment. That's one concern. And that's a second concern, which is, and I should say here, just to interrupt myself, not just amongst anti-vaccination groups, but amongst the Australian community. That's the concern. It's not just that. It's clear in the minister's reasons that he talks about others and stuff. It's not limited to anti-vaccination groups emanating in. The concern is that, he's a high-profile person who is in many respects a role model, and certainly for many people, and so that his presence in Australia would, present more strongly and more currently to Australians his anti-vaccination views, and at the same time, referring to what is said in paragraph 24, the applicant has at least some history and some recent history of ignoring COVID safety measures. So there's a reference in paragraph 23 to him, even when he was infected and had received a positive test, he undertook an interview and a photo shoot, which included taking his mask off. Now, that's publicly known, and the minister took the view that his presence in Australia would encourage people to emulate his apparent disregard for those kind of safety measures. Now, in that respect, the reasoning, which is, we say, quite rational and cogent, is that when you have somebody in his position who, as Your Honours will all know, and this again falls within the common sense idea, people use high-level athletes to promote ideas and causes all the time. The applicant himself, no doubt, has many advertising arrangements with different clients. So this is not, I'm not saying this is advertising, but his connection to a cause, whether he wants it or not, is still present. And his presence in Australia was seen to pose an overwhelming risk. And that's what has motivated the minister, as he says in his reasons, we say. I think I was just going through the section B 1.2 of my submissions, which runs from 13 to 19. I won't restate the summary of the reasoning process there, which goes mostly in 15 and 16. In 18 and 19, we do set out extracts from the reasoning of His Honour Justice Goldberg in Tian, and then Justice Branson in Newell, and we've emphasised certain passages in the bit that has been quoted. And we think that is ultimately important to understand that good order is not limited to just breaches the law, but involves, difficulties or public disruption in relation to the values, balance and equilibrium of Australian society. It involves something in the nature of unsettling public actions or activities. And then in relation to Newell, that was a case in which the person themselves had done nothing in particular. I mean, not in Australia, and there was no fear of the person doing anything in Australia, but just that the person's presence here would lead to an adverse reaction by other members of the Australian society. And so that just shows that the minister's approach is well within the accepted meaning of 116(1)(e)(1) of the Act. And paragraph 20 just seeks to reinforce that by saying that the legislative history shows that, and this will be relevant later, but if Your Honours have that handy, Your Honours will see that the current version says the presence of the holder in Australia is or may be or would or might be a risk to certain things. Now, when these decisions were made, it actually only said is or would be. So the test which was made was that, and then there was a reenactment to lower the threshold, and I'll come to this later, to be is or may be, or would or might be. So it sort of lowered the standard, or the threshold maybe, before the power arose. But what the Parliament didn't do is change the meanings or change the wordings of health, safety or good order. And according with normal statutory construction principles, that should be construed as Parliament adopting the judicially attributed meanings to those expressions. The next section of our submissions, which start at B2, deal with some matters of detail in Mr. Djokovic's submissions, and I won't address those orally. In paragraphs 25 and 26 of our submissions summarise ground one of the applicant's case and also identify the term counter-argument, which we've used as a kind of an abbreviation for the notion that's expressed in paragraph 26. Now that refers to a consideration that the applicant says was not taken into account. And at 28, we identify 3 reasons why this ground should fail. The first is that the ground is dependent on the court making a finding of fact that the minister did not take that argument, the counter-argument, into account. We say that finding should not be made. We would say, if need be, that the minister did consider that matter, but we don't need to go that far. It's enough for my client to succeed on this point for the court simply not to make the finding that the minister didn't consider it, because they have the onus, and if the court doesn't make that finding, ground one essentially disappears. Secondly, the second reason is that we rely on a legal proposition that the minister, or rather, the ground relies upon a legal proposition that the minister was bound by logic or reasonableness to take that consideration into account. We take issue with that. And then thirdly, there's a question of materiality, which I will address as well. Now, our first proposition is that the court should not find that this issue was not taken into account. Now, there's a heading C1 on page 6 of our submissions, which addresses this topic, and it starts off by addressing some foundational principles. 30 and 31, Your Honours can see, they're largely motherhood propositions. But we note in particular the conclusion that the minister didn't consider something as a finding that shouldn't lightly be made, and we rely upon the cases in footnote 8 for that. I won't go to any of those cases, I should say. The next propositions, or the next bundle of propositions, all relate to how the court should undertake this fact-finding task. Paragraph 33 indicates that an omission in a statement of reasons is insufficient to infer that a matter has not been considered. Now, another way of putting that is, even for a person under a duty to provide reasons, it's not necessary to refer to everything in those reasons. And we refer in footnote 9 to sundry cases that support that proposition. But we're not in that case. The applicant's position might be a bit stronger if we were, but there is an important difference between persons who have a duty to elaborate a statement of reasons and persons who don't. And the fourth proposition, which is in paragraph 34, is that where a decision maker is not under a duty to provide a statement of reasons, it just logically becomes more difficult to infer that non-consideration from any omission in a statement or a partial statement that is given. If your reasons don't have to be comprehensive, the failure to mention something is obviously less readily a basis to assume that it wasn't considered or to infer that it wasn't considered. And that proposition is clearly set out in paragraph 35. my friend takes issue with us leaving out something in that. We resist that, and we resist that because as we note in paragraph 12, that principle discussed in paragraph 35 has been applied broadly in the federal court to areas where people are voluntary decision makers. That is, where they're not bound to make decisions, as I'll come to, as is the present case. So in that sense, we do rely upon that. Now, we're not saying, and don't say my friend went this far, but we're not saying that there's some kind of legal presumption that if there's no duty to provide reasons, you can never draw an inference. That is not our position at all. We just say if there's no duty to provide reasons, it is much more difficult to draw any inference that the omission of some express mention to something, is readily turned into an inference. So there is a case which I should perhaps draw the court's attention to. I think it is in the bundle. It is called XA, and I seem to not have a note of that. What tab it is in the bundle? Tab 12 in the bundle.
Have you got a citation, Mr. Knight?
So it's tab 12 in the bundle, and it's relevant discussion of Justice Thorley starts at about 174, but perhaps most critically 177. And one sees His Honour, I won't read through it, but we say that is entirely consistent with our submissions, and we just embrace His Honour's summary of the law, which includes M64, being applied in circumstances just the same as we say they should be applied. Now, my friends say, well, against that proposition is Taulahi. As we've said, we don't say there's never a circumstance where an inference could be drawn. Taulahi was, of course, quite a different case to this case, because in Taulahi, which my friend took the court to, if you want to go back to that, which I think is in my friend's bundle, in paragraph 66, what was missing there, there's an indication of what that case involved in paragraph 66, and the essence of it was that the minister's statement of reasons indicated that the minister did not avert to the proper operation of 501c in making the cancellation. And then the reasons did little more than repeat certain things in the issues paper. There was no express mention in them of the fact that the cancellation decision could be revoked. So that was the omission. So the omission there was the failure to deal with some aspect of the operation of the law. Now, I accept that court, drew that inference in that case, but it's a question of fact. And we say, for reasons that I will further develop, that in this case, there's really no cogent reason to draw an inference that the minister didn't consider these issues, having regard to all the matters that were before him. The applicant's case is that there was matters relevant before him that somehow he just missed them. Now that notion seems to be based on two propositions: that attachment H, where some of that material wasn't mentioned, but as I've indicated, it was mentioned, so the minister is taken to have read it. And then the second matter is my friend's repeated reliance upon paragraph 22, Roman 2, and the alleged wrong references there, or references that didn't support the proposition. And as I've indicated, those references did support the principal proposition in that paragraph, and the parenthetical proposition was supported inter alia by attachment H. So, in a sense, that undercuts his whole case. So what we have is the minister having material that was relevant, that was before him, that he took into account, and were to believe that the minister somehow didn't think of the consequences of making, or what would have been the consequences of making a cancellation decision.
Mr. Lloyd, did I cut across the Chief Justice there?
No, you go ahead, Justice.
Yes. I wanted to ask you what irrationality means in this context. Does it mean no more than, bearing in mind that it's not the same as a failure to take into account a relevant consideration in the Pico Wall sense, is it sufficient that the minister was aware of the matter, or is it necessary to show that he was aware of it and took it into account and conducted some sort of balancing exercise and so on? What do you say about that?
Well, I mean, the first question is whether or not he, for them to succeed, they have to show that he failed to, consider the issue, and they say there's nothing in the decision about it, and as a result, you should infer from that he didn't do it. We say no, he doesn't have to do a comprehensive set of reasons. The Act under Section 133. C, E, and F draws a distinction. Under Section 133C1, there's an obligation to give reasons. Under Section 133C3, there is no obligation to give reasons. So you shouldn't just start from the proposition that if it's not mentioned, it wasn't done. One starts from a broader proposition, which is, well, it's not mentioned so-called expressly, but then a whole lot of other things are mentioned, which suggests that those matters were taken into account in the context of the decision-making process. And when they're taken into account in a matter involving both a broad discretion and a public interest, so he has in mind the possibility of unrest, whatever his decision, it becomes then impossible to think that one should infer that he didn't, that wasn't part of the balance. That I think is broadly how we would put it. I mean, we separately have an argument that he didn't need to consider it, but that's in a sense in the alternative. Well, it's not the alternative, but it's an additional argument. So I think I've addressed Taulahi and plaintiff M64. So we ultimately say it's a matter then to consider all of the relevant indicia. In paragraph 38, there are references to the fact that there's no obligation to give reasons in this case. Paragraph 39 is just the Wu Shan Liang principle and a recent authority expounding upon it. I won't expand upon that. 46th proposition, I'll just rely upon my written submissions. That deals with matters of statutory context. If I turn now then to our submissions as to why the finding should not be made, that's dealt with from the section beginning from paragraph 46. Now, remembering that this counter argument is basically about the consequences, or perhaps particular consequences, specific consequences of a decision to cancel. Now, in paragraph 47, there we make 3 points. The one is just drawing on the point we've already made that the mere omission isn't enough to support the inference. So that this isn't a case. There are some cases where somebody has had natural justice and they've advanced an argument, and then there's no mention of that whole argument in the decision, and then you might be inclined to draw an inference that that argument wasn't considered, because you would have expected to see, something more specific about it. We're not in that category. This is not a case where there was natural justice or where a particular argument was specifically raised, which we say weakens further that possibility. There's no suggestion that the minister didn't understand the statutory criteria, so that also weighs in favour of consideration, or at least doesn't weigh against it. And then we say, given that the onus is on the applicant, the court shouldn't, in this case, make a finding in their favour. But then we go further from 49 and onwards and refer to matters which we say show that the minister did consider the consequences of both sort of the cancel, non-cancel, the consequences of his decision, which whether it be cancel or not cancel in broad terms. So starting at 49, we refer there to the evidence that the minister has sought to consider things broadly. Perhaps I should go to the statement again at paragraph 7. At one point, my friend said that the minister didn't make inquiries and didn't explain why. That's just simply wrong. So if the court sees in the statement paragraph 6, that's the minister saying that he's not bound to make inquiries, knowing that he could make inquiries, and then giving reasons for why he wasn't going to make inquiries. So it's just not a case, like my friend says, of the minister not knowing. It's in that context that in paragraph 7, he says, taking into account the fact that he hasn't had the benefit of what might have come if information had been sought, he's done his best to consider the matters alive to the fact that the applicant, his views wasn't sought on things. So that suggests that the minister is trying to look at things broadly. So that is evidence to suggest that the minister was trying to take a broad view, and it's in that way that we use it. My friend says, well, it doesn't prove that he looked at this specific thing. No, but it does show the mindset of the minister to look broadly. So he's got all this information before him. My friend accepts that it is in the information before him. He just says it's not in the reasons. We say, well, it's in the information before him. The reasons don't have to be exhaustive. He's saying that he's looking at all these things. Then in paragraph 50, we say the matters in there. It's clear that the minister knew there were people who supported what they understood to be the applicant's position on COVID. It also referred to opposing reactions and to sources of discord. So the minister is aware that there are consequences for his decision, we say, both ways. That language is entirely consistent with, if not implicit, of that understanding. That is, the minister, we say, was aware that there would be groups who would be opposed to a decision to cancel. The minister, we say, must be taken to be aware that this decision would result in a high level of media, or whichever way he decided it. And so we say broadly that means the minister was aware of the possibility of reactions, whatever he decided. That is, reactions from groups that may affect health and also that may affect good order. Indeed, the minister expressly indicated that he was aware of unrest. And that is mentioned in our submissions at 52. So there'd already been some unrest under the previous decision to cancel. So it's not like the minister was unaware of that possibility. He was referred to it as a possibility to cancel. And so that is a factor that is taken into account, we say, expressly in that regard, which is at least part of the notion of both the so-called binary view. He's decided to cancel, but he knows that there are consequences each way, we say. We say the court should infer in relation to that reference to unrest, that the Minister would have been aware of the protests in Melbourne on Tuesday, the 11th of January, involving
Yeah, I hate
persons
to interrupt,
supporting the
but
applicant.
without this chat, everybody be
Again,
falling
on the
asleep.
Vian view, I mean, this is
Thanks
not just
for
some
showing
random
up,
protest somewhere in the
supporting,
world.
and
This
let's get
is
back to
the
listening.
day after the court's decision to set aside the cancellation. There's a protest about the exact matter that the Minister has told the world, in effect, that he's going to reconsider. So it's impossible to imagine that that wasn't within the Minister's understanding, and that we would say is at least part of what is being referred to as some unrest having already occurred. Now, in paragraph 46 of the submissions, which are referred to in paragraph 52, the Minister takes that unrest into account against cancellation. So that was a factor against cancellation. That is, the factor in favour of not cancelling would be less unrest from those groups. That's pretty self-evident, but it seems to be contested that somehow the Minister missed that. At 53 of our submissions, there's a reference to a range of adverse consequences, that other adverse consequences that were considered, and these were matters that were raised by the submissions on behalf of the applicant. And I won't read them out, but they involve, if you make a decision to cancel, it will prejudice Australia's economic interests, it will create an appearance of politically motivated decision making, it will call into question its border security principles and Australia's border security principles and policies. So there was a range of adverse consequences, including, this notion of, political issues, if I put it broadly. So again, this is the Minister being confronted with and actually expressly referring in his submissions to these exact possibilities. So it's not a Minister who's not thinking of the consequences of a cancellation decision or a non-cancellation decision. And paragraphs 55 to 60 highlight the material before the Minister. Now, we say that the fact that this was all before him, my friends, I think, rely upon it as saying this is the stuff that should have been considered. We say, well, it's in documents that are referred to by the Minister, and it was in any event in the submission, and the court should be very slow, not lightly to come to the conclusion that these issues were not part of his consideration in considering in both the public interest and the discretionary elements of his decisions, amongst others. So we say that that is all evidence that is sufficient to reject the submission that the court should make a finding that the Minister failed to consider the consequences relied upon by the applicant. So that is our first argument in relation to that matter. Now, I see the time, Your Honour. If Your Honour wants to have a break now.
First argument.
I think that might be convenient.
You gotta be kidding me.
Without binding you, or without intending to put pressure on you, how long do you think you'll be?
Well, I'm about just under 2/3 of the way through my speaking notes, so slightly less than as long as I've already been. I think
Okay.
I've been
round about an hour.
So probably about an hour.
Around about an hour, give or take. Okay, thank you. The court will adjourn until 1:30 Australian Eastern Daylight Saving, which is 1 o'clock in Adelaide.
So, welcome everybody to Hex Tennis channel where I'm streaming the live feed of the Australian court trial of Novak Djokovic. And wow, boring. Like we said in the comments, without the chat, this would be hard to watch, even though everybody's on pins and needles about whether he's going to stay or is he going to go. Now that argument by what I assume is the state, it was hard to follow. He seemed disinterested. He didn't seem passionate about it. And then apparently they're going to take a break and he's going to come back and do about an hour more of that. Wow. It's kind of tough. Yeah, thank you guys for appreciating the chat, and I like to have a nice free discussion, whether you're pro or con or whether you're just here just watch the show. Everybody's pretty much keeping it somewhat respectful. It's hard to follow with the speed of the chat. I'm pretty new to streaming, so yeah, tennis fans, we got a little spot here where we can hang out and watch this and hopefully get a decision soon. Seems like people are pretty much 50-50. Well, actually not. A lot of people like pie. 13% of you. It's interesting. So, a lot of people in the chat, 1,200 votes, say yes. Australia should lose the Grand Slam. No, 36. I think that probably falls along the lines of whether you're kind of pro-vax or not. And then you got people that are hungry, and I'm thinking about pie now. Yeah, in my opinion, you gotta take it for what it is. I'm from the US. If you're gonna have an open tournament for the world, you have to have it open, meaning you have to have everyone who's can play, able to play, whether they're vaxxed or not, whether they're different from you. You can't really have a true open tournament if you're going to close it off for apparently some people's feelings or thoughts or medical choices. Well, yeah, Fernand, you think we should put I like pie people in the yes section? That would be an overwhelming victory. There you go, Doug. Love thy neighbor, vaxxed or non-vaxxed. I mean, it's pretty shocking how all these countries and governments have people fighting with each other, have put a divide. You know, one day we were all in this COVID situation together. The vax comes along, and instantly, it was used to divide people. Vitaly, no decision yet. They took a break for lunch, and then the state's lawyer is going to argue probably about for 45 minutes more. And then I have no idea how long the three judges, are going to take to make up their decision. I got a feeling they already know what they're going to say. You know, this case with Novak, this is a case that everybody's got a little stake in, because every country all over the place, this is playing out in every city, every town. I mean, I'm from New York, and New York City, and you got the vax versus unvax here. People losing their jobs because they're not vaxxed or fully vaxxed. One shot is not enough anymore. You can't go to a restaurant unless you got vaccination card to show you pay. It's pretty outrageous.
Clothes with Rio hottest winter deals up to extra 15% off only on Rio.com and our
Is it really 2 hours before they're gonna come back? That's an awfully long lunch.
I'm going to teach you my drills, secrets, and keys.
I'd like to thank the players for letting me come out and record and enjoying the match. Now you get to see every single point of an 8-game pro set, and I hope you enjoy it as much as I did. And if you do, like and subscribe, tell us what you think in the comments, and enjoy the match. Yeah, Tony, you informed me about the copyright law, and I don't have any idea, so I'm just putting up a stream where people could chat while watching, share ideas, talk freely. You know, if you have a problem with that, then you're welcome to stay, you're welcome to leave. Yeah, I think if I get in trouble by the Australian government for streaming, they might deport me to Australia. You know, why, if this keeps going like this, maybe we'll have an unvaccinated tour and a vax tour. And if you're vaccinated, you can't play in the unvaccinated tour. And maybe segregation is going to come back. Let's make segregation great again, probably. Yeah, about the Czech player that was in the country with the same medical exemption, and then they canceled her visa a couple weeks later. I saw a tweet where they said that she was strip searched when she was taken into custody. I wonder if that's going to blow up. That's funny, Jared. You know what? Novak is a little weird. He might be into maggots, very healthy, no fat. No, this is not clickbait. We're taking an hour break because the court is out to lunch. When they come back, the state is going to argue a little bit more, and then maybe the judges come up with their decision. Yes, Djokovic's lawyers started off with the arguing, and then they stopped, and then the state argued for about an hour, and then apparently he needs about 45 minutes more, but then they took a lunch break. Yeah, I agree, Jared. All the problems in the world, all the issues, but at least this ain't like the Academy Awards giving Oscars for movies. find it funny how the ambassador, quote unquote, to tennis, Roger Federer, is sitting on the fence or on the sidelines on this one, boy. Man, Tony, you still here? I mean, by participating in this, you're making yourself part of the crime, an accessory. You know, explain to me exactly why me hosting this trial for people to see, and not only see, but have a place to discuss while it's going on, is a bad thing, and why I should lawyer up. So then, if it's copyrighted, then YouTube has a very strong system where it recognizes it and gives me a strike. I got a strike on my first stream because I showed a clip from Wimbledon, and the good people at Wimbledon gave me a strike. So they'll handle it. You don't have to worry about it between me and YouTube.
At Zappos.com, shopping is a little more fun. The most effortless way to shop online and only keep what you love.
But the actual court, Tony, is streaming it on their YouTube channel, and they're not monetizing it, so how am I stealing from them or infringing on them? Matter of fact, this could be considered commentary, which is allowed. We're allowed as a news organization to use footage as long as we're using it for commentary for like maybe the public's interest. I don't know. I'm not a lawyer. I only pretend to be one. There's a live feed. They're out to lunch. I figure watch a little tennis. I mean, this is a tennis-themed event. Unfortunately, I can't play copyrighted tennis. I have to play my own matches. Which, this is not me playing, by the way. These are two friends of mine. I know, the lawyers must be stuffing themselves with pie. That's funny. Yeah, I mean, I don't know the lunch customs in Australia, but does that come with a nap? Tony, what's your obsession? Yeah, I read the line on top of the screen, and I'm making a conscious decision to disagree with it. I think I have a case. Montana, the latest is that we saw probably the first half of the trial. Novak's lawyers made their case, took about an hour, and then the state lawyer made his case, took about an hour. He claims he needs another 45 so minutes, but before that starts, they took a lunch break. We're hoping it's an hour. Hopefully it's not more, and it's quite possible they're eating pie. It's quite possible Novak is dominating the ping pong table in the refugee camp. Yeah, they decided on second helpings. It's time with a little coffee.
No more layering clothes. With Rio hottest winter deals, up to extra 15% off only on Rio.com and our 24-hour all-inclusive hotels, now with a travel
We
medical
fully
insurance
expect the
included.
hearing to be
Reserve
back.
until January 17th.
If it was only an
Los
hour,
Cabos,
maybe we
Cancun,
got
Jamaica, and
20
Aruba.
minutes left.
Book now with up to 15% off.
But then again, I can't count. I'm monitoring the stream, and I'll put it on as soon as it comes on in my other screen. For now, I'm playing some of my random videos on my channel. I was thinking of making a compilation video of Roger Federer smashing rackets back in the day. You like to smash a racket here and there. Novak pillow. Yes, they'll work for both sides. The anti-vax will snuggle with it, and the pro-vax will pummel it. Noel is the goat of lying on forums. Man, all of us made a mistake on a form. All of us had to pick a box that we didn't understand. And all of us have lied on a form. This music piece, I gotta find a name for you, but it's copyright-free music from YouTube Studio. It's got nice songs in there that creators are free to use in their videos without getting in trouble. The songs that are in this video are listed in the description box of the video. I actually made an effort to do it correctly. I'm not inciting people to lie in a form. I'm just saying that people have done it. And I don't know why you're trying to turn this against me. I'm just hosting a stream. Whether you like it or not, you're free to stay, free to go. And if you want a little bit more information, I'm not vaxxed, but I'm not anti-vaxxed. So, there you go. Yeah, Patricia, I lied on my license application too. I put I was 5'10" when I'm really 5'9", you know, but I'm really hoping for a good growth spurt this year. Well, the feed is still not up. Still waiting. they're back. Let me get the stream on. Give me a second. I'll move it right over.
The harder it is to get to the point of suggesting that it wasn't considered, because some of them are just expressly considered. The narrower it is, the harder it is to draw an inference that it wasn't considered just because, or that it even had to be considered, because the more specific it is, what about this particular consequence? Did he consider this very specific thing? So we just say there's an issue about what the counterfactual is, but in any event,
Yeah. Another way of thinking about this that I was thinking about over lunch, that in a sense trying to reconcile the competing contentions about the submissions that were before the minister, and that the minister must have seen them and must have understood they were there, etc. One way of putting it, and I'd be interested to see what you say about it in terms of both as a question of fact and as what its consequences were, is that it might be that you, if I may put it this way, you are correct to the effect that much of this can be seen in the submissions in the existence of other groups that may have an anti-vaccination predisposition or view, the possibility of antagonism about the withdrawal of the cancellation of the visa, etc., etc., and one can, on this hypothesis, readily accept your submissions that this kind of problem was, in a sense, within the submissions that the minister, in a case such as this one, would hardly infer that he didn't read. That said, what he didn't do, on one view, was finally balance the weighing of them. And the answer to that may be that he didn't have to, but so that one can see a lack of balancing of one against the other, without denying the notion that he was alive to problems in the future if he did cancel. And then one goes back to what the statutory task is, and what consequence there is if he understood aspects of the future, but simply did not, as it were, finally weigh the alternative binary potential detriments.
Well, we would say that Your Honour not only should find that he had the issues before him and they were in his mind, but they must have been part of his consideration of the balance. So, for example, in paragraph 46, he says, I also acknowledge that Mr. Djokovic is now in the community and that some unrest has already occurred such that it is too late to avoid. This is in my mind against the public interest in cancellation. So he is aware of unrest and he is taking it into account, except that he hasn't said, expressly the other thing. But it's very hard to imagine that he wasn't aware of the possibility of further unrest of the exact kind that he's exactly just mentioned there.
And the answer may be that one doesn't have to frame it in frame the debate in some analysis of finally balancing opposite courses of action. It's sufficient that it's before you, taken into account, and one can see that there's a degree of consideration.
We would certainly embrace that, certainly. If I go on to our next section, our written submissions is C2. So this is now, as it were, on the assumption that we've lost the first ground. If we win the first ground, that's the end of ground one. If we lose the first ground, so the court is now considering the situation that the counterfactual wasn't considered, then we still have an argument to the effect that that isn't a jurisdictional error. We address in paragraphs 65 to 70 some authorities which the court will be very familiar. I won't even speak to them, other than to draw particular attention to 69 and 70, the kind of language for an unreasonableness case about it being necessarily stringent test, not lightly interfere, needing extreme illogicality. And in a reference which I don't think we have in our submissions, but I'll just give to the court now, it's the reasons of Chief Justice Gleeson in Re Minister for Immigration and Multicultural Affairs, ex parte applicant S20 of 2002, in 2003, 77 Australian Law Journal Reports 1165 at paragraph 5, where His Honour said to the effect that even emphatic disagreement doesn't demonstrate unreasonableness or illogicality. So we say that to sort of set kind of the background principles. Then against that, we look at this case. And we say it has to be decided in whether something is unreasonable has to be decided in a statutory context. That here is section 133, capital C3. First, there's no statutory criteria identifying what the minister must consider in addressing the public interest. So that's a very broad scope. Nor does the Act identify any matter that must be considered in exercising the discretion whether or not to cancel. So that is a further broad scope. Probably it's convenient now to say something about a case my friend mentioned, which is Acting Minister for Immigration, Citizenship, Migrant Services and Multicultural Affairs, and CWY 20, 2021 FCA FC 48. I think it's in my friend's bundle. I think it was actually provided very shortly before the hearing this morning, in fact. Now, in that case, first of all, I ask the court to go to paragraph 133. We would certainly embrace what is said there, in which Your Honour, Justice Basenko, I think, was observing that sort of questions of this kind as to whether, well, I'll just read it. For these reasons, the primary judge's conclusions that the acting minister did not give active consideration to Australia's non-refoulement obligations in his assessment of the national interest is correct. That is a factual finding, and I do not consider the reference to Carrasco a different case with different reasons and issues to be of assistance. So the notion that it's a kind of fact-specific issue, we embrace. The next thing I'd say about the case is we also don't challenge or dispute what is said in paragraph 157 or 160, that the mere fact that something is something is not a mandatory relevant consideration, that fact alone doesn't mean that it cannot be unreasonable for a decision maker not to consider it. And in paragraph 160, in the fourth line, the point that is made there is a reference is made to section 501A2. That a comment is made in relation to that, obviously to that extent, the case affects no qualification to our case, so it doesn't trouble us. We embrace what we think is explicit, or at least they're very much implicit in Your Honour's judgment, and that is that unreasonableness depends on particular circumstances of the case. I won't take Your Honours to it, but we rely upon paragraphs 148, 149 and 154. And what was important in CWY 20, as we read it, is the clarity with which the acting minister had in substance found that an immediate consequence of his own decision was that Australia would be in breach of international obligations, and yet not having regard to what the consequences of that would be, and taking that into account. We say that that is a very different case to this, in a different nature, and so it's not a case which requires Your Honours to come to the view that that there would be unreasonableness here if the matter was considered. One has to look at it in the circumstances, the statutory circumstances, and here statutory circumstances are not about Australia's international obligations or provisions which actually have been understood, at least by reference to the practice in the 501 area, to have regard to such things. But this is an area where the minister has a very broad discretion. The second aspect of statutory relevance here is section 116(1)(e)(1). So that's the power which is being relied upon. Now the focus on that section, and I think we've taken the court to it earlier, is the presence of a visa holder in Australia. That is, it asks what will happen if the visa holder obtains or retains a presence in Australia. Obtains because it applies if somebody's outside of Australia, and retains if they're in Australia. And if I just give the court a reference to the decision of in Justice Kohlberg in Tien and the Minister, 1998, 89, Federal Court Reports 80 at 94. There is no statutory counterfactual that is required, we say, under section 116(1)(e). It doesn't ask what might happen if the person is removed or not present in Australia. We do not say that that's an irrelevant consideration. It's something that could be considered. It's just not a mandatory consideration. There's nothing in the text which suggests that looking at a counterfactual or failing to look at a counterfactual would be irrational or unreasonable. The powers in section 116 and 133 reflect the sovereign right of the Commonwealth to determine who is bound to be in Australia. The Commonwealth ought not to be bound to suffer the presence of an alien for fear of what might occur if they were removed, which is in essence what the applicant's case requires. We might have to allow an alien to be here because we're concerned about what would happen if we removed them. We say, given the breadth of the public interest and the discretion and the breadth of the matters that the minister did consider, it doesn't follow that the minister, from the minister not considering the counter argument, if that's what the court finds, that he transgressed the bounds of reasonableness. Now, that counter argument is really just one factual dimension of the risk of unrest, and the minister clearly turned his mind to that topic. The last issue we address in relation to ground one is materiality. The way we put that is that when Well, first of all, the onus for establishing materiality lies on the applicant. He would need to establish that had the minister considered the specific thing he said was not considered, the result could realistically be different. Paragraph 78, we say that the court should not be satisfied that there is such a realistic possibility of a different result. We say that because when one considers the matters, and we say in our written submissions 48 to 59, but those paragraph numbers were not updated, so it should be 49 to 60. There are the matters I've taken the court through, the sort of broad-ranging considerations about the consequences of the decision, that broad range of consequential analysis that was taken, that there's no reason to believe that the issue said to have not been considered could have made a difference. We say the minister was well aware of anti-vaccination activist groups. He was aware that they idolised the applicant for his stance on vaccination. He was aware of the prospect of discord. He was aware of competing groups and views in Australia. He was aware of the likelihood of publicity, whatever the outcome. Now, what on that hypothesis did the minister not consider was how all of the things accumulate to some very upset people if the decision was cancelled. We say that's an incremental drop of thought of what was already a very substantial pool of thinking on the whole consequences issue, and it could not realistically have made a difference to His Honour's outcome. That's all we wish to say about ground 1. I might now go to ground 3 because in a sense it's logically comes before ground 2, at least on our way of thinking it does. Our submission start, or the relevant bits of our submission start at paragraph 105. It was said that it was not open to find that the applicant opposed vaccination against COVID-19. And the materials I took the court to in Annexure B provide, we say, ample support for the view the applicant is opposed to this vaccine. We refer again in paragraphs 107 to 109 to that material. I won't go through it again. In a no evidence case, there only needs to be a skerrick of evidence, and there's much more, there are not only multiple skerricks, there's actually material substance to suggest that, and we rely upon that. There's one further matter which maybe to answer my friend's submission. He sort of said something like, this is really perhaps going into the next limb of the case, but it occurs to me now. He says, well, there should be evidence that if if the applicant has an effect upon the level of vaccination, that should have occurred by now, and there should be evidence of that. Now, I accept that the minister doesn't put it in these terms, but if the court looks at page 29 of our submissions in the annex, one would, applying common sense, think that Mr. Djokovic's iconic status must be highest of all in Serbia. So if you were going to see an effect that his anti-vaccine views might have, one would see it in Serbia. And what that evidence does show in about the 6th paragraph, or the 2nd paragraph from the bottom, it says, in Djokovic's home country, where it is estimated that under half the population is fully vaccinated against COVID, his comments were criticised at the time of government epidemiologists, etc., by creating misconceptions. So in that context, we don't accept that that is something that had to be done, but such as it was, there is even some evidence that of this. So if the minister had to find such evidence, it was even before him. Now, while that's all I want to say about that part of ground 3, we say that's clearly open, but the fact that the applicant is opposed to vaccination against COVID-19 in the sense discussed by the Minister. Then there's at paragraph 99 and following, there's a discussion of a failure to make obvious inquiries point. In paragraph 100, we refer to the authorities that indicate that this is a rare ground and one difficult to make out. The mere fact that it might have been reasonable to make an inquiry does not make the person bound to make it. I won't ask the court to go to it, but in tab 11 of the bundle, there is a case called Kaur, or Kaur, I'm not sure how that's pronounced, versus Minister for Immigration and Border Protection, 2017, 256 Federal Court Reports 235, and at paragraph 33, the full court endorsed various single judge decisions at that point to the effect that I just said, which is that just because it would have been reasonable to make an inquiry doesn't mean that it's unreasonable not to make the inquiry. In relation to this, we then address 3 reasons why this failure to make an inquiry point should be rejected here. The first is whatever the applicant might have said in a letter in response to such an inquiry about his current vaccination views would not have altered the fact of his previous stated views and the impression held by the Australian community. And as my friend has made clear when he's gone through the Minister's reasons, a large part of the issue is not just what his views are, but how his views are perceived, and relevantly among the Australian community. So to that extent, it's no reason to think that there was any duty to inquire. The next and second point is that there's no evidence before the court that the applicant could or would have put forward any useful material to the Minister had his views been sought. He has chosen not to put on any evidence in this trial. That material, we say, is required, and in that respect we refer the court to the Minister for Immigration and Citizenship and SZIAI 2009 83 Australian Law Journal Reports 1123 at paragraph 26. That is the High Court saying it, probably in obiter there, but still it's the High Court's obiter. And then we also refer the court to a decision of Justice Stewart of this court in ERE 18 and the Minister for Home Affairs number 2, 2021 FCA 1346 at paragraph 50. I won't take your honours to it, but it's tab 9 of our bundle. And that was in the context of the immigration, the IAA, and whether it unreasonably failed to obtain new information. And His Honour noted that that no evidence had been adduced as to what new information could have been provided. And so we say this is simply a consequence of the principle that the applicant has the onus to make out the point, and they haven't made out the point. And the third reason is in relation to our submissions on the alleged failure to acquire. Any such failure has to be conceived of, we say, as either legal unreasonableness, so that the failure itself isn't a jurisdictional error, but if it constitutes legal unreasonableness or a constructive failure to exercise jurisdiction, then it could be. For that proposition, we rely upon what Her Honour Justice Bennett said in SZMJM and the Minister for Immigration and Citizenship 2010 FCA 309 at 30, which is one of the cases that was approved in Kaur, which I mentioned earlier. And in SZIAI, the High Court wrote in terms of unreasonableness and constructive failure as well at paragraph 27. And we say here that there could be no constructive failure to exercise the power under Section 133(c)(3) by not seeking information or comment from the applicant when it's recorded that the minister is not bound to accord procedural fairness. That's a significant factor on affecting what was required. More significantly, the minister, we say, didn't overlook the possibility of asking the question, so it's not unreasonable. He adverted to it in paragraph 6 of his reasons, which I've already taken the court to and I won't go back to. And he says his reasons for not doing it, which are not unreasonable or even said to be unreasonable. And in the IAA context, in matters concerning challenges to not obtaining information, the giving of intelligible reasons for not obtaining new information has been sufficient to avoid findings of unreasonableness. And I'll give you on as an example of that at DYK 16 and the Minister for Immigration 2018 267 Federal Court Report 69. The Minister is engaged in reasoning, the Minister also engaged in reasoning alive to the fact that the applicant's views had not been sought, and he makes that clear in paragraph 7. No challenge to that statement has been made, and we say it should be accepted at face value. So we say there could be, in any event, no unreasonableness or failure to exercise jurisdiction in the circumstances of this case. That brings me to the last ground, which is ground 2. It starts at paragraph 79 of our submissions. That ground challenges the finding of the minister along the way to being satisfied of the ground in 1161E1. The finding that is challenged is that the applicant's presence in Australia may foster anti-vaccination sentiment. The first section, I think before I go to that, my friend also makes this point about paragraphs 19 and 39 of the minister's statement. I think this is as apt a place as ever to deal with it. So he reads paragraph 19 of the minister's statement to say something which it just simply doesn't say. He reads paragraph 19 to say, as if he says, I, the minister, have no idea what Mr. Djokovic's views are about vaccination. And then my friend says, well, how ridiculous is that? In paragraph 39, he purports to say that they're well known. This is the most egregious breach of the Wu Shanliang principle you can imagine. It has to be read as a whole. He doesn't say in paragraph 19 that he doesn't have a view on what Mr. Djokovic's views about vaccination are. He just says, which is accurate, he didn't ask for, as it were, an updated view, what his present attitude is. And then he explains why. So there is no tension. So to the extent that my friend's argument about there's some illogicality in it or unreasonableness or there's no basis for it, I mean, it's clear that there's a basis for the view as to Mr. Djokovic's views about vaccination, and paragraph 19 provides no tension. My friend just, we say, misreads it. Now, returning then to ground 2, the nature of the finding here is that the applicant, not that he has fostered or will foster, it is that he may foster anti-vaccination sentiment. Now, in terms of section 116E1, it is about whether something, namely presence of the person in Australia, may, we focus on that word may, be a risk, focus on the word risk, to something else. And the something else in this case is harm to health, safety, or the good order of the Australian government. So then at 83 of our submissions, we focus upon the word risk and point out that it has a future element to it. It speaks of the future that we're told by my friend is uncontroversial, so I can move past that. Then in 85 to 87, we look at the word may and the legislative history, which shows the lowering of the threshold from what used to be is or would to instead be is or may or would or might. That amendment in itself, to anybody who reads it, would think, oh, well, the Parliament's obviously trying to lower the threshold. If there's any doubt about it, the explanatory memorandum expressly says that they seek to lower the threshold. That's in paragraph 86. And in 87, we say it has also been construed as lowering the threshold. So we say that that's right. Now, what is addressed in 88, which my friend embraces as well, is cases about what happens when courts, those two cases cited there, what happens when courts make assessments as to the future, and they are allowed to, undertake reasonable conjecture, having regard to, what's known and past events. But the fact that the process is a process of reasonable conjecture still has to be read with the actual test being the low test of is or may be. And so, as it were, 88 doesn't cancel out everything that comes before it. It works with them. And so what the minister, and if that's what's required of the courts, then an administrative decision maker obviously has more flexibility than a court in terms of that kind of future gazing. And a minister undertaking a broad public interest, non-compellable power, we would say is broader even still.
But Mr. Lloyd, engaging with what's put against you, I think, as I would understand it, you can correct me, or the Wood would correct me, that Mr. Wood, in a sense, in his submission, he's saying, well, where's the evidence? You have to have facts, and we could have had examples in other places from the last year of encouragement, as it were, or people following his lead, if I may use that expression. But it's important, I think, to identify the two, wrong to put them into two categories, but for the purposes of discussion, I'll use two categories. That is, one, being taken up by those who have strong vaccination views. But second is a much broader concept of an iconic sports star setting an example that is not wished to be followed. And as I would understand your submission, is that the notion that you have to lead evidence about what effect he had in the United States of America or somewhere else is just not to the point. One can use one's common sense and human intuition about this from how people behave. And take the example, if Mr. Djokovic, as he has done on a number of occasions in the past, won the Open, there's an example, embedded in the Minister's reasons is there's an example for young and not so young fans of tennis.
Indeed, and our point is that we don't have to show what happens in Serbia or America, wherever else he's played tennis. It's not required. There was that bit of evidence which I took the court to about Serbia anyway, But more importantly and more recently, maybe because of, perhaps inevitably because of more recent events, the applicant's views about, or widely understood views about vaccination have been come to the fore. So they're right in people's minds at the moment. The minister has to make a decision about risk, having regard to what has just happened recently, and how he has now become an icon for the anti-vaccination groups, and then what role that will have if him, somebody of his significance being present in Australia at a time when that is the issue. And the minister clearly sees that there's a risk that, in the same way as I don't want to, I won't do that. In the same way as Mr. Djokovic advertises or associates himself with a whole array of products, and no doubt because of his popularity and status, that does well for those people who engage him for his endorsements. Rightly or wrongly, he's perceived to endorse an anti-vaccination view, and that is perceived, his presence here is perceived to contribute to that and to foster further sentiment of more people who are maybe undecided becoming anti-vaxxers. And then, of course, if that happens, that's what leads to the healthcare consequences. And we just say that the known facts, the facts of Mr. Djokovic's views, or at least the perceived views, the knowledge of his perceived views and his historical views and his unanswered views, in combination with his status and presence, could be seen to contribute significantly to those issues. And that's all that's required to make the inference that the minister made. So on that basis, we say there was evidence. It was just starts with the material that we've said, and then one draws inferences from that, being not wild inferences that people of Mr. Djokovic's status are able to influence people who look up to him. And that seems to be, one might have thought, common sense and uncontroversial in having regard to how celebrities engage in all kinds of, not just commercial advertising, but all kinds of other political and other roles. Then the last, I think that probably I've addressed paragraphs 90 to 91 of our submissions on the no evidence point. We basically say that there is evidence sufficient to draw the inference that was drawn. Then there is an illogicality point which starts from 93 to 98. We have, I think, in substance addressed that issue already as well, but we say it's not illogical, and
that's really ground three, another iteration, isn't it?
Indeed, we think that's how we see it, and we've probably approached it in that way. So I think I've addressed that. Now, I think one thing I had not yet gone to address that. I've addressed that. May it please the court, we would say each of the grounds should be dismissed, and there should be an order that the applicant pay the minister's costs.
Thank you, Mr. Lloyd. Mr. Wood, in reply.
Yes, Your Honour. A brief reply. I'll only reply on ground one. My reply points are inspired partly by two questions from the bench. One was a question of Justice Basenko before lunch, and one a question from Your Honour the Chief Justice to my opponent after lunch. And the underlying issue here I might call awareness versus consideration. Justice Basenko's question to my learned friend was, is it sufficient that the minister was aware of the matter, or is it necessary to show that he was aware of it and took it into account and conducted some sort of balancing exercise and so on? And whilst I don't have in print in front of me, Your Honour, the Chief Justice's question, I gather that it was rather the same issue.
It was really the same. It was really the same issue. I think you can deal with them together.
Yes, I will. Thank you. Now, the answer, Your Honours, is that consideration was required in the circumstances of this case. The reason, Your Honour, is helpfully illustrated by the decision of CWY20, which was referred to by me earlier and by Mr. Lloyd, but again, the citation 2021 FCA FC 195. Now, different decision, but shared some common features. So that was a decision under 501 capital A of the Act, which is a power of the minister without natural justice to, in effect, substitute for a favourable decision of the tribunal an unfavourable decision of the minister. The conclusion of the court, 5 members of the court, including, as I recall, Your Honour, the Chief Justice and Justice Basenko, was that in the circumstances of that case, it was unreasonable for the minister not to consider the consequence of the decision that he ultimately made, but for the challenge, being refoulement of the applicant from Australia, given the way that the minister had framed his own reasons. The point was, this is the critical point of CWY20, that what the minister had said in his reasons demonstrated that he was aware that if he made a cancellation decision, the consequence would be that the applicant would be refooled by operation of the various provisions of the Act that made, at that point in time, removal mandatory despite the existence of non-refoulement obligations. The critical point, or a critical point of the judgment, is the paragraph that I referred to earlier, which was 130 within the reasons of Justice Basenko, where Your Honour, Justice Basenko, citing the various cases therein, said, well, in effect, there's ample authority for the proposition that one doesn't read into a statement of reasons produced by a decision maker findings, reasoning, in effect, consideration of a matter that aren't there. Now, it was trite. It was the very precept for the controversy in CWY20 that the minister was aware that non-refoulement would be the consequence, but the conclusion of the court was it was unreasonable not to consider that in assessing the national interest. Now, that is a useful illustration of a few points. One is this, that unreasonableness, and that may be the more apt concept to apply with respect to ground one than irrationality, but they're obviously concepts that are informed by the same underlying legal values. Unreasonableness can be used to deprecate not only findings and reasoning as expressed, but the process by which the decision was reached. And in CWY20, what made the process unreasonable was the fact that the consequence of the decision, refoulement, was not considered. So as the court was at pains to point out, despite the minister's strenuous arguments to the court in that case, it wasn't about pico walls and mandatory consideration. The point was the minister, by his own findings and reasoning, had in effect rendered it the consequence of the minister's own findings and reasoning meant that it was unreasonable not to consider the very consequence that the minister's adverse decision would have, being refoulement. So that reflects, of course, High Court authority. Again, this is sort of fairly trite, but it just occurred to me when I was thinking about this earlier, so I'll mention it, which is ABT 17, 2020, 269, Commonwealth Law Reports 439, where a majority of the High Court at paragraphs 19 and 20 make that point quite crisply, that unreasonableness can deal with not only findings and reasoning, but process leading to the point.
What was the paragraph number?
Paragraphs 19 and 20. Now, in that context, let it be assumed, for the sake of argument, that the minister was aware that an adverse decision of the kind that he made might be apt to stoke anti-vax sentiment. Let's assume for the purpose of discussion, I'm not admitting this, let's assume, however, for the purpose of discussion that he might have been aware of that, either in the sense that the minister's a member of our society and there was a protest in Melbourne during the week or whatnot, so if you like, common knowledge. Or perhaps let's assume that the minister was aware of that because of the content of the back end of the BBC report that expressly said that there'd been anti-vaxxer activity galvanised by the cancellation decision. The point and the essence of ground one is this, and it's why it shares features with CWY20. As soon as you accept, as we say the court ought to, that the minister had clearly identified, particularly as bearing on what the minister thought bore on the public interest, paragraph 39, the risk of doing anything that would strengthen anti-vax sentiment, that was the minister's own chosen criterion or issue of concern. As soon as the minister did that, linked it appropriately in the exercise of his broad evaluative powers to his own assessment of what bore on the public interest, it's a critical feature of his decision. If one attributes, as I've contemplated, awareness to the minister by either of or both of the means I've suggested, common knowledge or awareness of the relevant part of the BBC article, then it becomes perverse or unreasonable, is a perhaps fairer term, for the minister not to do something with that awareness in assessing where he thought the public interest lay. In other words, if the minister was aware, then it called for an evaluation. It called for balancing. Now, this is what segues, and I'm at least halfway through the reply, don't be too concerned. This is what is a useful segue to what I might call the Taulahi point. Now, respectfully, Mr. Lloyd hasn't really distinguished Taulahi. It's on all fours. Same comprehensive statement of reasons, described as a statement of reasons, identify those features in particular by the full court as the basis upon which inferences that something not mentioned were not considered. The height of Mr. Lloyd's argument, and it's not that high, is that one might take bits and pieces of the minister's reasons, or perhaps common knowledge, to suggest a possible awareness. But what one does not see, and we don't accept that, but I'm treating it as the premise for the purpose of this point in argument. What one doesn't see is what one would expect to see in a document styled as a statement of reasons, apparently comprehensive, an engagement by the minister in a necessarily evaluative exercise of where the public interest lay, if indeed, as again I've indicated, for the sake of argument, awareness of the possibility of anti-vax aggravation consequent to coercive state action, in other words, cancellation and removal, was in play. Now, can I conclude the point in this way? The relevant attachment, setting aside common knowledge, if you like, as I said repeatedly in submissions in chief, the only relevant evidence was attachment H. But attachment H spoke to various different things. Page 1 or page 2, if you like, was essentially the point in April 2020. Mr. Djokovic said some things about vaccination. It is that aspect of attachment H, and only that aspect of attachment H, that is referred to by the minister in his reasons. That's paragraph 18 and paragraph 41. Nowhere, anywhere in the reasons, does the minister refer specifically or by any fair inference to what I'll call the second half of the BBC article, which spoke to the anti-vaxxer aggravation that has emerged, at least in Melbourne, in part this week in response to the cancellation decision. One simply doesn't see it. So it is, Your Honours, getting back to this distinction between awareness and consideration, a stretch indeed even for the Minister to submit that the Minister was aware of it. All that the Minister did was speak to a quite distinct proposition emerging from that document. But as I've said, even if the Minister was aware of it, even if it's to be assumed in the Minister's favour that he carefully read the whole document, the whole BBC report, what is damning in my submission, in light of the Minister's own clear articulation, particularly in 39 of his reasons, of what concerns him, anti-vaccination sentiment, that there is not even a reference to the evidence, but certainly no discussion or weighing of it in the ultimate assessment of the public interest. And that leads to my final point, and it might be thought obvious, but it needs to be said. A couple of times, Mr. Lloyd submitted that Australia, and an attempt, this is not an exact quote, it's a paraphrase, Australia ought not to be bound to tolerate the presence of a person in Australia because of what might happen if that person were removed. My answer is trite, and it ought to be, I'll draw that. This case is not about, as admin law rarely is, about whether the Minister could have, after considering this relevant point, whether the Minister could have cancelled the visa. That's not an issue that ground one of my client's application invites this court to conclude. It's no part of our argument, and it would violate orthodox principles of administrative law. Our point is that the Minister, having erected his own criterion of concern, and in light of the singular evidence before him, setting aside questions of common knowledge, indicating that anti-vax sentiment clearly was being provoked by the coercive state action that had been engaged in at the airport, the cancellation, drawing from the same underlying principles as CWY 20, it was unreasonable for the Minister not to consider that evidence, the only evidence, in assessing what the impact of either of the binary decisions would be. Of course, ultimately matters of weight were for the Minister. Our point is, as a matter of fact, it clearly was not evaluated, and it follows that the decision ought to be set aside.
Your Honour, may I say something about my friend's reply?
In a moment, Mr. Sorry, Mr. Lloyd. In a moment, Mr. Lloyd.
Your Honours, the only thing I wanted to say, again, is not earth-shattering, but in terms of relief, if the court were persuaded there were jurisdictional error, we would seek not only quashing, but an order requiring immediate release, say within 30 minutes or thereof of the court's decision. An order of substantially the same kind was made by Judge Kelly on Monday in the week past. And of course, the court is aware of this, but there are many cases, obviously, where if circumstances of urgency demand, of course, it's open to the court to deliver orders in advance of reasons if the time permitting would not allow for the articulation of fulsome reasons.
Yes, Mr. Lloyd.
Two things, one in relation to that, well, two things. One is my friend's case in paragraph 19 of his amended application in ground 1 is premised upon the Minister having not considered the matter in 18B. In his reply, much of his reply was spent saying, well, even if he did consider it, he was unreasonable in what he did. That's not the case. We haven't come to answer that case. That is a different ground. And we say, Your Honour, insofar as it exceeds the pleaded ground in ground 1, Your Honour, should not be embracing this idea that this case is about the reasonableness of the decision per se, or even if he had considered these things, it was still unreasonable. But that is not, we can't deal with that now, and that's not the case.
Just let me examine that for a moment. Your argument is that you put in writing and orally is that these things were considered, and even if they weren't considered, there's no jurisdictional error.
That the failure to consider them is not a jurisdictional error.
Yeah, quite.
What we haven't addressed is whether, even if they were considered, it was still unreasonable for the other reasons that my friend sought to develop in his reply.
Mr. Wood, did you want to say something?
I do. I think it's become important to clarify this because there seems to be genuine confusion. The point is this. We say, and we've used different terms, but I've focused in reply on the term unreasonable. It was unreasonable not to consider.
Yeah.
Not that the consideration, getting into the merits, if you like, was unreasonable. Quite clearly, our point is it wasn't considered in the sense that it was not evaluated. Now, to be perfectly clear, 18B of our amended application said, relevantly, the question of whether cancellation and consequent detention and so forth of Mr. Djokovic, on the basis of a few lines of text he said 2 years ago, may also foster anti-vaccination sentiment, and if so, the significance of that to the assessment of the public interest in the exercise of discretion. So the point that I was emphasising in reply, picking up on the questions from the bench, was let it be assumed that the Minister is aware of evidence, in other words, had read the BBC report fully, was therefore aware that there had been, as that report said, galvanisation of the anti-vaxxer community following from the cancellation. Awareness of that evidence, this is really
not consideration.
Exactly. And our point is...
And the way you put your argument is I would appreciate it. And if this is not correct, my appreciation is faulty, that if the court were of the view that Mr. Lloyd's submission should be accepted about consideration, you have a problem. Ground one is dismissed.
I agree. So if the court finds that the Minister did consider the evaluative sense, not just aware of evidence, but considered it in assessing whether public interest lay or whether discretion should be exercised, then on ground one, I lose.
Yeah, okay. Mr. Lloyd, is that?
I accept that, yeah. If that's how my friend puts the case, then I accept that that's within the bounds of his application. Right. The only other matter I was going to raise, which doesn't arise from a reply, but only from what he said at the very last bit, but I apprehend that the court, if the court makes a decision today, if it's obviously in my client's favour, then I have nothing further to say, but if any one or more of the grounds are upheld, and apprehending that the court won't obviously be in a position to give reasons today, it would still be of assistance to my client in order to inform any further steps he may wish to take to know which grounds were said to be made out. Thank you, Honour.
Thank you. Thank you. Just a moment. Thank you, Mr. Holmes and Mr. Wood, Mr. Lloyd, and your juniors and solicitors for the careful and thoughtful way the arguments have been put together, and with the economy of their delivery. The court proposes to adjourn. What we would hope to do is to spend the afternoon, hopefully, and perhaps the early evening, dealing with the arguments that have been put to the court, not with a view to delivering full reasons today, but with a view if possible, to reach a view as to the outcome of the matter, and on one hypothesis, if it be relevant, Mr. Lloyd, the individual basis for it, if that is view of the court. We would hope to do that later in the afternoon, and so in a sense we're not asking counsel and solicitors to stand down in their present position, as it were, but we would hope to be in a position to identify to the parties later in the afternoon what the course is that we propose, and then we, on one view, may well come back this afternoon or perhaps tomorrow morning to deal with the matter in the best way we can, and take it from there. And we will make some form of announcement on the court website if the matter is to be relisted and when it will be relisted. Is that satisfactory to the parties?
Yes, Your Honour.
Yes, Your Honour. Yes, Your Honour. Thank you.
Thank you. Well, the court will adjourn in the circumstances that I have identified.
All stand. This court is now adjourned.
Wow, later, maybe this afternoon, maybe tomorrow morning. They're really dragging this out. They know what they're gonna do. You know, why are they dragging this out? Anyway, I'm gonna keep the stream up for a little bit. This way you guys could filter out. And I want to thank all of you for coming, spending Friday night, for me at least, watching this very dry trial, but has big consequences for a lot of things, whether you're a tennis fan or not. And do me a favor, if you're into tennis, like to watch amateur tennis, I got tennis videos up on this channel. You could subscribe, help me with my channel. I'll try to keep this story updated as best as I can. And maybe we'll be doing another live session tomorrow at a court hearing. Hopefully not. But we have no resolution tonight. There's not much that could be said about that. But pretty much I let people speak freely in the chat, and it was very contentious. People on both sides, but pretty much it was pretty polite, you know, and that's exactly how free speech should work. And I dig it. So I'll hang out here a little bit and contemplate what the hell's gonna happen next. Hey Tommy, that's interesting. What's my view? And I'll be honest with you. I'm from the States. I'm from New York. We have our vaccine mandate issues here, and I'm personally dealing with a lot of issues because I'm not vaxxed. I'm not against vaccination, but I'm against choice. I make my own medical decisions based upon my opinion and how I communicate with my doctor, and I never say never. I may get the Johnson & Johnson because it's one shot. I may not. So I'm a tennis fan. This is interesting, not only for tennis now. It's become a political fight that's bigger than tennis at this point. And that's pretty much where I stand, you know. I don't want to shout down people who are vaxxed. I don't want to be shouted down by people who are vaxxed. But, yeah, that's my stance. Very close to Utah, Nico. This is Sedona, Arizona. We went there for tennis nationals for the USTA Tennis League, and I flew from New York to Sedona, Arizona, actually to Surprise, Arizona, and our team took a shellacking. But the experience was great. So we had a day and we took a nice drive, and I went up to Prescott Mountain, which is another video. Beautiful landscape. I may have to move there. tell me my favorite player. Very interesting. Well, I grew up idolizing John McEnroe, bad boy tennis. And favorite female tennis player, Steffi Graf, and we're talking old school because I'm a little older. But Martina Hingis, I mean, no big weapon in anything, but great at everything. So if you want to model your game, amateur game after somebody,
with Rio hottest winter deals up to
Martina
extra 15%
Hingis.
off only on Rio.com and price.
Dr. D, this car is 2020 Grand Cherokee Jeep. I rented it on my trip out to Arizona for a tennis tournament, and we took a ride out to Sedona. Oh yeah, I forgot to say Novak's in the back seat. Materiality did not. Well, they said they may come back later this afternoon. That may be a few hours. They said they may come back tomorrow morning. So I'm just keeping the stream up a little bit because there's still about 800 people here chatting away. But I don't think we're probably going to hear anything tonight. And I'll probably be shutting down the stream in probably a few.
Small business owners, use Melio to send and receive ACH payments completely free. Melio is
Yeah, Uber Eats. It's funny, I delivered for them for a little bit, but their prices are too low for the drivers now, so I haven't done it in a while. Judges left us saying that they could come back later this afternoon, could be a few hours, or they could come back tomorrow morning and make their decision. So we're left hanging. I'm keeping the string on because there's still over 700 people here, but I say I'm gonna give it like 10-15 more minutes. I'll shut it down. If they come back and I'm aware of it, I'll come back. If not, we may see each other tomorrow, hopefully. This is still in Arizona. This is me driving through Prescott Mountain, and we're in the city of Jerome, which is an old historic gold mining town from back in the day, and it's pretty interesting history. They say the city's haunted. No, we were staying in Surprise, Arizona. Didn't make it to Scottsdale. We were there for the USTA Nationals tennis. My team made it to Nationals in mixed doubles, and we had a good old time. We had 17 people from the team go. We were all hanging out, and this was an off day. And I took my rental car for a nice drive with Novak in the trunk. Thank you for the compliment on my voice. Boy, did I hate my voice when it first when I first heard it on video. And it took me a while to upload videos on my channel, but after trial and error and trying to build a channel, I got over that. A little white Mike Tyson. Well, yeah, I got heavy New York Bronx accent. And yeah, actually, I saw Mike Tyson in a strip club one time. And boy, he did look tiny, but his neck, I was just amazed at the size of his neck. And nobody was going near him. This was back in the day where he would snap and beat you up without even thinking about it. It's pretty interesting.
I want to take on the world's toughest hack.
Okay guys, I'm going to play this last video, and then I'm going to end the stream, and I wish you all have a good night. I doubt we'll get a decision later on, unless they try to sneak it on us. But a lot of people commenting on my accent. Yes, I'm from the Bronx, and here's a video I did that was pretty good, and it's of historic streets of the Bronx past. Hope you enjoy it, and after this video finishes, I'll be shutting down the stream. Thanks for hanging out, and see you soon.